And in case any of you are not aware, the day one is uploaded already on the KW United YouTube channel. So you can reference that. We got that updated, uploaded for you guys on Tuesday afternoon. All right, let me find our materials in my background and get us started. Okay, so residential sales contract is where we're going to start. I'm going to try to go through this in the order that I also like to see the documents when we're reviewing them. It's an order that just makes sense to me when you're presenting an offer to other agents. It's always best to have that residential sales contract on top. I don't like to see disclosures or anything like that on top. The residential sales contract should be on top. Of course, that's secondary to the buyer cover sheet. But when it comes to the contract documents, the residential sales contract should be the first thing that your client, that the agent on the other side sees, and that your clients see when they're signing. So this contract is fill in the blank, just like every other document we have that we've gone over. It's fill in the blank. We're not attorneys. We're not supposed to be writing contract language. On some of the addendums, it does turn into that. And I will give you the do's and don'ts about writing that language. But for the most part, this is strictly fill in the blank. Okay. So we're putting in the top section that the contract is offered on whatever date. So that's the date that you're filling out the offer. Again, that date, just like on our agency agreements, really isn't relevant. It's the ratification date that matters. Okay. The buyer's name on here is their legal name. How are they going to take title? And the seller's name on here is their name as they currently are on the deed, which in most cases is going to be exactly what you see in the tax record. When you're looking in the tax record, you need to look to see if it makes sense how the name is written. Sometimes they invert first name and last name, so it looks like a little gobbledygook. Sometimes you will see that an individual's name is in the first line, and then there's a line like 4 down from that. It will say company owner. That's where it's going to be an indication to you that the home is not owned by the individuals, that it's owned by a trust, or it could be owned by a business. Whoever the actual legal entity is that owns the home, so the name on the deed is what goes as the seller. So if it's a trust and it's the Mickey Mouse Family Trust, you would put Mickey Mouse Family Trust as the seller, and then Mickey Mouse and Minnie Mouse would be signing as the trustees. Okay. Their names don't go up in the signature line, only what's on the deed. Okay. The next 2 lines reference the brokerages, the listing brokerage and the cooperating brokerage. So that means the buyer's brokerage. Okay. Then you have real property. So real property section asks not just for street address, which is what the Postal Service uses for mail. You also need the tax map and ID number and information from the legal description. So this is all found in the tax record. There's a link from the MLS to get into the tax record. You can also go directly to the county website to log in and look. But in, I'd say 99.9% of the cases, you're going to be able to get the information right from the MLS. An issue that comes up regularly is parking spaces. I'd like to point out to you that in parking spaces, if you are in a townhome or a condo where there are assigned spaces, but they are not deeded to the property, you do not write anything here. We did talk about that on the listing agreement, and I'd like to just remind that unless the parking spot is deeded to the property, which means it has a separate deed of its own, you do not write anything here. The HOAs own the parking lots and the condo associations own the parking lots. in communities where they have just assigned spaces. And so they can take the assigned spaces away at any time, just as they can assign them at any time. Section 2, price and financing. For those of you that have been licensed since before January 1st, you will notice this section has changed. This is one of our changes that was effective January 1st. What we did here was we just rearranged so that it was apparent right at the top what the offer price is. So this first line is what your client's offer is. The next line is the down payment. So if they are paying cash, then those two numbers are going to be the same. So if it's a $500,000 house, the sales price is $500,000, the down payment is $500,000, financing is $0. Okay. If it's a $500,000 house and their down payment is 10%, then their financing is 90%. I'm going to encourage all of you to use the percentages and not the dollar amounts in this market. We have many opportunities to be in counteroffer situations, and this section is very important to our financing contingencies. And if the numbers don't line up, your client could be at risk of not having their financing contingency. So when you have a counteroffer and the sale prices change, so let's say it was 500,000, and so you put $50 in contingency for your financing that matches up and could be at risk if your client is declined. Okay. Right here, the financing section, the first trust, the buyer is telling the seller what type of financing they're getting. This is to be filled out regardless of whether you're making the contract contingent on the financing. It will carry down what the total financing is. And then seller subsidy, of course, is the credit from the seller to the buyer towards their closing costs. Okay, so that's all right here in section 1. Gailey, yes.
Shannon, in the case of a VHDA loan, you would check other and put VHDA, but if it's a conventional loan through the VHDA, do you then also check the conventional box?
Okay, so that's a good question. So there's no such thing as a VHDA loan as a first trust. Okay. VHDA is a grant or loan for the second trust. So there's always going to be some other base financing,
right,
with VHDA as the second.
So is there anywhere on there that you indicate it's a VHDA backed product, or do you just check conventional or FHA and you don't put VHDA anywhere on here?
So you would indicate on the second trust if it's a loan, because it's a grant towards their down payments, right?
Okay, so you don't actually put VHD in here, but you do fill out the second line.
If it's a loan, right? Exactly.
Thank you.
Exactly.
Ms. Shannon.
Yes, we do.
For you say for sell price 500, if it's cash offer and you can put down payment here 500.
Yes.
And is for financing, you can put other is cash.
So there's no financing. So you don't even put cash.
Okay.
You don't put anything. There is no financing.
Okay. Seller subsidy. Seller subsidy. What is the maximum for facility? Is for 600. Say we can closing cost 10. Okay.
Lisa, you're breaking up.
Okay, right now?
A little bit. So are you asking about a seller subsidy on a cash offer?
No. Seller subsidy, not cash offer. Seller subsidy, what is maximum percentage? He can do it.
Well, you can do a percentage or a dollar amount.
10,000 is okay. He can, he say, I need to full closing cost. So 600,000 house and buyer asks 10,000 is okay, is legal?
Well, yes, anything's legal. It's a matter of what the lender will allow. So the lender is not going to allow anything more than what the actual closing costs are. So before you make the offer, you're talking to the lender to find out what the estimated closing costs are, and then that's what you put down.
I get it, man. Thank you.
Okay, you're welcome. Okay. So the next section talks about whether the offer is contingent or not
Hey,
on
Shannon.
finance. Yes.
Jeff, sorry to interrupt. Where it says total financing, we had this problem yesterday. I just checked it. When you put 20%, then it comes in here and puts the zero over there, and it doesn't get rid of that.
Yeah, that's okay. It's a function of the fact that DocuSign is set up to add together each column. So if you don't fill in each column, then it is just going to leave one of them as zero.
So there's confusion when it says $0 amount, but then it's 20%. Like there's no issue them contradicting each other.
Well, it says 0 or 20%.
So it's okay. All right.
It's okay.
So we just put a line on the zero and put 20%.
So Z, what he's saying is that in the cash side, it will say 0 if nothing's filled in the cash side, and then it will still say 20% on the other side. So you don't have to cross out 0 because it says or.
Okay.
Okay. All right, so on the financing contingency section, this is where your buyer is telling your seller, do they want to make this contract contingent on financing? Now, this is a soapbox moment for me because most agents, and especially their clients, don't understand what this actually means. When you waive a financing contingency, it does not mean that the buyer has smooth sailing all the way to closing and that there could be no issues. What this means is that the buyer is willing to put their earnest money deposit plus the risk of being sued for damages on the table, on the line, to win this offer. Unless they have cash in their bank account to back up the loan amount that they are applying for, they are still physically contingent on someone else giving them money in order to get to the closing table. So the contingency is solely about who can go after earnest money and damages. Okay? So this has to be explained very clearly to sellers when they get multiple offers that come in and they see something that says no financing contingency, but at the top it's filled in saying, I still have to get a loan, right? Someone who is a VA buyer who's doing 100% financing and is contingent on financing can still be the stronger buyer against someone who's doing conventional financing with 10% down and waiving their contingency. Okay, that VA buyer might have a ton of money in the bank, but it is their benefit for serving our country that they get to finance 100% if they qualify. Okay, so they still could be the stronger borrower. So these are all things that have to be looked at when it comes to whether a contingent contract on financing versus not contingent is the stronger offer. Okay. Now, this paragraph goes on to say that within 7 days of ratification, the buyer will make written application for financing and homeowners insurance. So this is something as a buyer's agent in your checklist for timelines, you should be verifying that your client has finalized their loan application with the lender and that they have reached out to their insurance company. Our jobs, once the contracts are ratified, is to hold the clients accountable to the promises that they've made. Remember, we talked about how you don't actually need a contract for the sale of real estate. Somebody shows up with cash, somebody shows up with keys and a clear title. At the title company says, I want to sell my house to so-and-so, so-and-so says, I want to buy it, and it can be worked out. They don't need to have the contract, right? The contract is so that the promises are clear that each side is making during that period of time from when the agreement is made and the settlement date. The next section here says appraisal contingency is or is not contingent. Now, there's a second piece that was added to this, because if the buyer has told the seller up here that they are getting a loan, then in a lot of cases, the lender wants to have an appraisal done, even if it's not contingent, okay? The lender wants an appraisal done. So there had been some confusion with sellers when an appraisal contingency was waived on whether or not they had to actually let an appraiser in if the buyer's lender required the appraisal. So this section says the contract is contingent or is not contingent on the appraisal. And if the contract is contingent on financing, the seller will provide the appraiser reasonable access for the appraisal purposes, okay? Pretty straightforward. Then it goes on to say if it's not contingent on financing or appraisal, the seller will or will not provide an appraiser reasonable access. Okay, so why is this? Well, this might be in a scenario where the buyer says, I'm paying cash and I don't need an appraisal contingency. And then they decide, well, maybe I'm gonna apply for a loan anyway and see what happens, because it's cheap to borrow money right now, right? Even though rates are going up, it's still cheap in the grand scheme of things to borrow money. So then the listing agent gets a call saying, you know, Joe Smith's lender needs an appraisal. What can we get in? And the seller's like, what do you mean their lender? They said that they were paying cash, right? So this is setting the expectation up front that the seller will allow appraisers access, even if there's no contingency. Even if they say they're paying cash, they will or will not allow the access. Okay, that is something new. Does anyone have questions on that piece before I move on to the next section?
Cash offer, you don't need to appraisal contingency.
Can you repeat the question, Litu?
Ma'am, cash offer, you don't want to do appraisal contingency, cash offer?
You can. Some buyers still want an appraisal with a cash offer.
But it's not a financial contingency, say is not. Because
Right.
it's not a
If they're
relation
paying-
for pay
Correct.
cash.
Correct. If they're paying cash, there's no financing contingency, but yes, they could still have an appraisal contingency.
Okay, thank you.
Okay. So the second part of this paragraph says that if it's not contingent on the appraisal, the buyer has to go to settlement no matter what the appraised value is. Okay. So what that means is buyer's getting a loan and buyer waives the appraisal contingency and they negotiated that 525 sale price off of the 500 list price, but it really only appraises at 500. Well, they don't get to negotiate now to lower the price or walk away because they're not contingent on the appraisal. That means the buyer has to pay the extra $25,000 in cash, because in our scenario where we talked about 90-10, what happens there is the lender is going to lend 90% of the purchase price or the appraised value, whichever is less. Okay, so in this scenario, 525 was the sale price. 500 is the appraised value. So the lender is going to lend 450,000. Okay, so the 10% according to the lender is 50,000. Buyer said, I'm going to pay 525. So they really do their 50,000 plus 25,000. Okay. Who has their hands raised? Young, I'll go to you first. Try your space bar if you can't unmute it. Nope. You want to type it in the chat? All right, does somebody else have a question? I thought it said 2 hands were raised, but.
Okay, I'm sorry.
Oh, there you go.
I clicked a wrong button.
Okay,
Okay, on the contingency part.
Mhm.
I understand what you said, that it doesn't matter if they have a cash offer because they can still do an appraisal.
yes.
But let's say it's a different kind of loan, like whether it's conventional, VA, whatever type of
Mhm.
loan, it depends on what the lender wants. So if the lender says we require an appraisal, then you're going to have to check it's contingent on an appraisal.
No, so that's where the second part of that first paragraph comes in right here,
Okay.
where you can waive the contingency, but you know your lender is going to require the appraisal because you're not putting enough money down, right?
Okay.
Usually the appraisal waivers only come if there's more than 20% being put down. So let's say your buyer's only putting 10% down. So, but they want to waive their appraisal contingency, then you check no, it's not contingent on the appraisal, but yes, the seller will let the appraiser in.
Okay.
Because it's not contingent doesn't mean that there will not physically be an appraisal.
Okay.
So that's why we added this, so that
So
you're
it's
saying,
keep-
hey, we know there's going to be an appraisal, Mr. and Mrs. Seller, you have to
Okay.
let them in,
Okay.
but we're still going to move forward regardless of the value.
Okay. I understand that. Thank you.
Okay, perfect. All right, Gailey, I think I found yours was the other hand up.
I'm sorry, mine's up from last time when I was actually.
Oh, okay, no problem.
I'll take it down. Sorry.
No problem. Just want to make sure I get everybody. Okay. Buyer's representations. So will the buyer occupy this as their primary residence? Yes or no? So what they mean by primary residence is, does this buyer plan to move in to this property within 60 days of settlement, right? That's what the occupancy affidavit is that they sign at closing. So they could, be offering a post-settlement occupancy and things like that. And that's okay, as long as it's within that 60 days. But this is, does the buyer intend to occupy this as their primary residence, right? If it has a tenant in it and they're going to honor the lease for another 6 months, not a primary residence. They're buying it as an investment property, not a primary residence, okay? This also says that unless specified in a written contingency, i.e. on the contingencies and clauses addenda, neither this contract nor the financing is dependent or contingent on the sale and settlement or lease of other real property. Okay, so what does this mean? This means that a buyer who has to sell their home in order to qualify for the financing to purchase the home they're writing the offer on cannot get out on a financing contingency if they're declined because their other home doesn't sell, unless they put the home sale contingency in the contract. So you can't try to misrepresent to a seller that you don't have a home to sell and think in the back of your mind, okay, well, if the sale falls through, it's okay because I'll get declined for the financing. This is very specific that is a misrepresentation and it doesn't qualify. Okay. And we will go over what that contingency looks like on the sale of a home when we get to the contingencies and clauses addendum. Deposit. Okay, there's a big, huge, in my opinion, awesome change to this paragraph. So in this paragraph, it says that the buyer will deposit in the amount of blank by check or wire, or blank by note. Excuse me. We don't do notes. Don't ever fill anything into that section, okay? So I'm just going to skip that. Buyer will deposit in the amount of blank, check or bank wire, to be held by title company, escrow agent. Okay, so this is your earnest money deposit. So generally speaking, in Northern Virginia, this is a minimum of 1%. When you're making an offer, the stronger the EMD, the stronger the offer can look, and the more at risk your buyer can be, because the EMD cannot be released unless all parties to the contract sign the release documents, or it goes to closing and then the EMD gets credited towards their costs, okay? There are a couple of other ways that the deposit can be released, but we're not going to get into the nitty-gritty of that. So just know, for all intents and purposes, the buyer's deposit is in that escrow account with the title company until either all parties sign a release because the contract is killed, or goes to closing, and then it moves from the escrow account to be applied towards the closing costs. Okay, hands are up. Young, is your hand up from earlier still? Or do you have a new question? I think yours might be from earlier. Anya, I'm going to go to you.
Yeah, I have a question regarding the note. You said we don't use notes here. Is there a reason why it's left, or is it like different parts of Virginia does allow notes?
Well, we allow them, but it's impractical.
I guess what would be a note? I don't know what that means, I guess.
Have you heard of an IOU?
Yeah.
Okay, so that's what it is. It's saying that I'm signing a document saying when something happens, then I'll pay the title company or escrow agent X amount of money, right? So they're not actually depositing anything. They're signing a document saying at some point I will pay. So it's
I see. Okay.
It's very hard to collect on.
Got it. Okay.
Okay.
Thank you.
Yep. Pam.
Yeah, in Oregon, they used promissory notes all the time. There was no problem with them. And they were like 3 or 4 days after acceptance. But my question is should you wait and put like 3 or 5 days until the homeowners association docs are looked at, so they don't put the money in there and then have risk if they revoke?
No, well, so there are ways to get the earnest money back if the seller won't sign, if it's clear. So there are ways, and I would say no. The answer is no. You don't put the extra number of days, but wait for the HOA docs, because you don't know when the HOA docs are going to be delivered. There's no law in Virginia that says they have to be delivered at some point from ratification, like we have in DC, right? So in Virginia, you get them when you get them, right? The law is that the HOA and condo associations have to deliver back to the homeowner who ordered the docs within 14 days of ordering them, but we don't have a requirement on when we have to deliver them to a purchaser.
But what about the earnest money agreement? Is it automatic, the money, the earnest money, is it refunded directly to them if they revoke because of them? I mean, you don't have to have a seller sign. Okay.
No, it's not. And when we get to the end, you'll see where it says that the seller has to sign when the contract is voided and those types of things. And we're not entering, remember, this isn't about earnest money deposits, right? Too much of our contract and our negotiations revolve around earnest money deposits. And that's not really what it is. It should be about getting to closing. So we should never be making an offer with the intention of voiding on HOA docs, right? If we're making an offer with the intention of voiding on the HOA docs, then we shouldn't be making the offer at all. When we get to the second section about the number of days where it says buyer has delivered or will deliver to the escrow agent within blank number of days after ratification, this is so that it's clear on the logistics of when the deposit is going to be there, not giving you time to not deposit, because the release still has to be signed stating that the buyer gets their money back, even if they haven't physically given the money, right? Because there could be some other situation where the buyer tries to void and they can't. Let's say they missed the deadline on HOA docs. The buyer's agent thinks that they sent the notice to void before and they didn't. So the deposit really is due and now the buyer's in default. So that release still has to be signed regardless. Okay. All right, some things in chat. So the EMD can be anything. The question is, what does it have to be? So it has to be something that makes your buyer look serious and put skin in the game for your buyer and that the seller will accept. Now, I will tell you in the Fredericksburg area, when I first took over as the broker, I hadn't really done any deals in that area when I was selling, right? It was outside of my area of expertise. So I didn't do transactions down there. When I started reviewing the contracts, I was seeing $500, $1,000, and this was on $200,000, $300,000, $400,000 transactions. It stressed me out a little bit, but that's the way it's done in that area, right? It's a smaller earnest money deposit is what's an acceptable business practice. Up inside the Beltway, really 1% is the minimum that a seller is going to look at and think you're serious as a buyer, especially in this market. Now, I had one years ago where I had called, I spoke to the agent. These were sellers that had owned the home for 25 years. I asked the agent, I said, what's important to your sellers? And you know what she told me? She said, EMD. The EMD was important. It was a $600,000 listing. My clients put down $25,000 in their earnest money deposit because they were putting 20% down as their down payment anyway. So this didn't exceed the money they needed for closing anyway. And that helped them win the deal because of the earnest money deposit. So it just all depends on what the seller is going to accept. Now I'd like to highlight something that is new in this contract that is super, super, super important that everybody understands. If the buyer fails to timely deliver deposit to escrow agent, seller may, at seller's option, deliver a notice to void the contract. This is different from any contract that we've had before January 1st. So before January 1st, if a buyer did not deliver their EMD, as an agent, our responsibility is to notify all parties that the deposit has not been delivered, right? That's our responsibility. If the buyer never delivered their EMD, the seller couldn't do anything. It was simply a breach of a contract term, and you still had to keep moving forward. Okay. Now we have provided the option for the seller that up until that earnest money is delivered, the seller may deliver notice voiding the contract. So if it says that the deposit needs to be at the escrow agent within 5 days after ratification, and on day 8, that deposit still isn't there, the seller can serve notice to void, kill the deal, go back on the market, and sell to somebody else. Now, if on day 8, the buyer delivers that deposit, and then on day 10 is when the seller is notified that that deposit was delivered late, the seller cannot serve notice to void because the buyer is no longer in default. Okay, they are considered in default as soon as we pass the deadline for delivering that deposit. Okay, agents are responsible for communicating whether or not the deposit has been delivered or not, which is why in command, it is a required compliance item for buyer side and seller side to provide proof of delivery of your earnest money deposit. Because I would not like for any of you to have to pay fines to DPOR because of this. Okay. All right. There are some hands that are raised. Gailey first.
So just to be clear, they have to give you the full time. Like I always put 3 days. So they can't, you have to hit day 3 and it isn't there. So you're in day 4. Now you're in default. If they don't catch it and you deliver it on day 4, then there's no harm, no foul. It's only if the seller were to catch it on day 4 that they could void.
That's right. That's the exact scenario I just laid out. If the buyer cures the default before the seller has delivered the notice to void, then that's it.
And they
Everybody
can't
moves on.
void prior to the deadline happening, obviously.
Right, because no one's in default.
No one did.
Right.
Okay, thank you.
Yep. Teo?
So I know that they're adding this to kind of make it more strict for adhering and they can void, but is there any like ramification beyond voiding that the buyer would be responsible for not delivering EMD?
No, they just lose the opportunity to buy the house.
Okay, but there's not like damages the seller can seek for having it getting taken off the market.
When a contract is void, there's no damages. Everybody goes back to their position prior to the contract being ratified. It's like the contract never existed. Emma?
I hate to be repetitive, but I just want to make sure that I've got this right. So if you say that the buyer has 5 days to deliver and the seller doesn't decide to serve notice until day 8, maybe because they're just hoping that the buyer will go ahead and submit the money. But like, so if it's supposed to be on day 5 and then they submit the money on day 7, it's still fine. It's only if would there be a situation where the buyer would say, it's day 5 and 2 hours, we're serving notice?
They can serve notice at any time up until the buyer has cured their default. So what I would say is agents stay on top of your EMD delivery timeframes, because you don't want to get into a situation where your client, your seller decides to serve notice to void at 4 o'clock in the afternoon and the buyer delivered the EMD at 2 o'clock. And then you have to go and get proof of the time of delivery, right? So just stay on top of those timelines and make them reasonable, right? It's not business days. It includes weekends. It includes holidays. It's days, calendar days. We do not change things to business days, because if I ask you what a business day is and I ask someone else what a business day is, I'm going to get a different answer. Because when it comes to money, a business day, how many of you, let's stop sharing for a second so I can see all of you. A show of hands, how many would say a business day is Monday through Friday, excluding holidays? Okay. How many of you would say that a business day. Now, this is when we're coming to counting money, right? How many of you would say that a business day includes Saturday? Michelle, I see your hand. Anybody else's hand? Pam? Okay. All right, so Michelle's hand was first, and Michelle is correct. Good job, Pearson team. So it is including Saturday because Saturday is a banking day, right? When it comes to the escrow and deposit requirements for not title companies, but brokerages in general, it is business banking days. So the holiday where the bank is closed doesn't count, but Saturday counts. So when you go into these contracts and you start adding business days and, you know, different things, everybody's going to have a different idea of what counts as a business day. So that's why we don't change the pre-printed language in the contract. We fill in the blanks and then everybody has the same expectation. Okay. Vivian, is your hand up because you have a question or because you were answering?
No,
On
on
the-
including Saturday as a business day.
Okay, awesome. Good job. All right.
Shannon,
Nasha,
is the deadline 9 p.m. still for E&D deposit days? Why?
everything in our contract is 9 p.m. except when it comes to HOA and condo docs, which I will get to when we get to that paragraph.
Thank you.
Nashin.
Question, so on the note due and payable on, so that's the exact date, but then below you're writing, I guess, how many days that is?
Nope, you're skipping that completely. You are not using notes.
Oh, that's only for notes. Okay, got it. Sorry.
All right.
Okay, Michelle.
So, and I see in the chat, there was a question about using it from 3 to 5 days for delivery. I think I addressed that you need to take into account when you're writing the offer and what your client's situation is on when they will be able to deliver that deposit. I would not go with a standard. I would say I would not do anything less than 3 days. And there may be a situation where you need to have it longer. And so you need to talk to your clients. Maybe they need to transfer money from one account to another because they haven't done that yet from your buyer consultation, right? When you're in your buyer consultation, you're talking to them about earnest money deposit and how much they have and what account. So you need to be checking with them. So each case is different. There is no standard. Litu, you had unmuted. Do you have a question?
Yes, for example, you are ratify contract Friday, and you have 3 days, Saturday, Sunday off, Monday for also for holiday. What the situation?
For depositing the earnest money?
Yes.
Yes, it's still due on Monday if you're ratified on Friday. So think about that. If you put 3 days and you know Monday's a holiday.
Unfortunately, I don't know, but I don't know. I don't know for he can ratify for Friday. I contract for Monday this week, example, and he ratify Monday, and I forget Saturday, Sunday regular off, and Monday for is a holiday, and I cannot go for with correct universal title. And what is the situation?
So what I'm going to tell you is that when you're also thinking about who your escrow agent is, let's see if I still have it on my phone. I don't know if I still have, oh, I do. Okay, so I'm going to show you, if you're using universal title, I don't know if you can see this. This is called the Zachem app. So it doesn't matter if it's a holiday or a weekend or 2 o'clock in the morning or 3 o'clock in the afternoon. Your client can deposit their EMD to the title company. They can deliver their deposit right here on their smartphone. Okay, so we need to be aware of that as well. So if you are using a partner of ours, like Universal Title, that provides this service to us and our clients, then it's a piece of cake, right? Why do we have partners? To make the whole process streamlined, right? And so that's one of the benefits that they provide to us.
And Shannon,
Hey,
just
yeah.
kind of as an agent note on that, it would be that you could do that before the file is open. So you don't have to wait for UT to send you the email saying, welcome to UT, we've got your file. You could send the money on a holiday Monday before that would happen.
Yeah, you have to. You have to send it. It goes through the app based on the address. You have to send it within the number of days. The file being open is not relevant to delivering an earnest money deposit, just as if you were handing a check to them, or just as if it was a wire transfer. The bank will accept it regardless of whether Universal Title knows about your file. It's just a matter of where they apply the money to once they see the deposits that come in.
Shannon, real quick on that too. My understanding with the Zocom app from when I've used it, check. So I've had clients who didn't have any checks, and that's why we needed to do a longer date as well. So those conversations, anything can happen where you can't get the money there in 3 days, 3 or 4 days. It took them a week to get new checks.
Well, and that's a conversation for your buyer consultation, right? None of this is an emergency or a fire drill, and none of this should be something that you're finding out when you're doing the offer. Because again, we talked about this on Monday, when you're doing your consultation or your follow-up to the consultation, once they've signed your document, no matter if it's a seller or a buyer, you're reviewing the offer, the basic offer package, so that they understand what the terms are that they're supposed to be thinking about, whether or not they have money in the right account for their deposit, where's the money coming from, have they talked to their lender, what settlement date they're looking for, who the title company is that they're going to use, all of these things, right? These are things that are not supposed to be decided after they've seen the home and they're like, oh, I have to put a deposit? I didn't know about that, right? It's all about setting the expectations. All right, we're going to move on. Settlement date. This next section says, this buyer and seller will make full settlement on or before with mutual consent. With mutual consent means signed addendum prior to whatever the date is you put in, okay, on or before. So everybody's target date is what you put in here. If they want to settle before, the title company and the lender are going to require an addendum. Technically, the contract is fine, right, without it, but the title company and the lender want that with mutual consent piece tidied up. All right, so that would be on a sales contract addendum. Now, if settlement date falls on a Saturday, Sunday, or legal holiday, then the settlement will be on the prior business day. I want to tell you guys, around Labor Day, I don't know if everybody was in summer vacation mode still, or was on summer vacation and not paying attention in August when they were writing offers, but I cannot tell you how many situations we had where the agents did not figure out that they wrote offers for a settlement date on Labor Day, and then subsequently didn't realize that closing had to be the previous Friday. So please, please, please look at a calendar when you are putting in a settlement date. Please, I beg of you. It does not automatically go forward to the next business day. It is the previous business day, because as soon as you pass that settlement date without a signed addendum, somebody's in default. Now, all of this, oh, I have something in chat. EMD, once EMD is deposited, does the escrow agent contact everyone? Okay, sometimes yes. So Universal Title does through Qualia. If you have entered all of the information for all of the parties, there will be a receipt in an email that goes out to everyone that confirms that the EMD was received. Not every title company provides that service, so you'll need to just monitor that. Okay, so back to settlement. All of this in bold is statute, okay, that says, and I'm going to paraphrase, that the buyer gets to pick the settlement agent and it's not negotiable. This is like a notification. Hey, seller, just letting you know, this is who's handling the settlement. So what does that mean? What that means is it is a RESPA violation for there to be a requirement of a seller for a buyer to use their settlement agent as a term to ratify the contract. Okay, that cannot be a requirement. It can be a request, but it cannot be a requirement. Second thing, it does not matter where your seller signs. I should never, ever, ever see anything on the contract about where the seller signing. It is not necessary. That's why there's no line for it. Nope, nobody needs it, okay? The buyer side handles everything when it comes to money and paper and recordation, okay? So who handles all the funds? Buyer's title company does, okay? Who handles preparing all of the paperwork, doing title search, preparing the deed, all of that? Buyer's title company. Who handles recording the deed and dispersing the funds after closing? Buyer's title company. Seller can sign wherever they want to, but what they are signing is the paperwork that was prepared by the buyer's settlement company. Okay, so the buyer gets to direct who is handling the settlement, period. Are there any questions on that? Okay, I see all the time a counteroffer that says seller will sign with blank.
I guess,
Not
Shannon,
yes.
I've had situation that this listing agent is forcefully saying, no, we're gonna sign with somebody else, and they're putting it on a contract. I mean, it's not a problem, right? It's just, it shouldn't really not go on there. I just don't ever want to get in a situation with the listing agent, especially these days, right? To trying to preach. I'm like, well, this should not go on there because it doesn't really matter if they're saying, well,
yeah, and I would just tell them, your seller can sign wherever they want to. It's no problem. And if that's the only change, that's going to hold up ratification, and according to them. But truly, it doesn't even need to be initial. It's nothing. It's not a negotiable term. It's just nothing, right? So that won't change. It won't change anything as far as whether the contract's ratified.
Mhm. And then you said that it's a RESPA violation to force the buyer to use the seller's title company, correct?
Yes, it cannot be a condition of acceptance of the offer.
So is it okay to put in the optional information, the information that you attach to the documents, the seller prefers to close with such and such a title company?
Absolutely.
Okay.
Absolutely. You can put seller prefers to universal title. And if the buyer doesn't have a preferred title company and they want to make their offer stronger, then they will probably put universal title, right? Mm-hmm. But it cannot be a contingent piece of acceptance of the offer from the seller.
Understood. Thank you.
What if the seller's title company gives an incentive to close with them? Like with my new construction, they're giving the buyer $500 to close with them. Is
Okay.
that
So builders, I can't even talk to how they get away with certain things that they do. In general, what you've just described is a RESPA violation, especially because it's financial. There's a financial incentive, and that is a big fat no-no. So I will say that builders do a lot of things, and again, I can't get into the hows or whys because it blows my mind. But a general rule is it's a violation.
Yeah, and the same with the lender. They're giving $9,500 to them.
Yeah, that's The lender piece is a little different because that's generally built into the rate and any lender can do that. Nothing's free. So let's move on to down payment. This is just a thing that says down payment will be paid on or before settlement date with certified funds, cashier's check, or bank wired funds. As a reminder, please talk to your clients and make sure that they know that it has to be a wire if it cannot be an ACH transfer. Title company escrow accounts cannot accept ACH transfers. They will have to return or reject that ACH, and it can take days before it gets back into the client's account. It has to be a wire transfer. And the wire information should be sent securely to your clients, and then your clients verify via phone to the title company those wire instructions before sending it. And I will tell you, when I just bought my house, I was very nervous wiring my down payment, and I was sending it to Universal Title. So it wasn't even like I was sending it somewhere that I didn't know, right? And I was still very nervous. And I kept pinging them. They probably thought that, you know, I was fulfilling my end of the bargain of being a high maintenance client because everybody was warned that it was my purchase, right? But I was like, did you get it? Do you see it? Do you see it? Do you see it? So please just remind your clients, wire transfers. Delivery. Okay, this is another fun paragraph because I see it filled out in all kinds of ways that stress me out. This has nothing to do with HOA docs or condo docs. This is for everything else. As a buyer's agent, if you do not fill anything in the seller section right here for email, you have to deliver important notices via mail or courier service or hand delivery, like tape it to the front door, to the property address. So if your client wants to void and it's a little contentious and you want to make sure that the seller side gets it, that you've done it properly, and you have not put anything here to the seller for email, you have to go to the property and tape it to the front door and provide proof that you taped it to the front door in time or that you've mailed it in time. Okay. For delivery, I'm going to suggest that it is always you as the agent in this section. And when you're filling this out for the seller, that is always the listing agent. Now, when you're, a listing agent and the buyer's agent is not paying attention to your instruction sheet, your optional listing information sheet, and this is blank, you need to fill it in and everybody needs to initial it. Because again, they then have to deliver all notices that are important in a different way. So.
Shannon, can I ask a question?
Sure.
So the delivery is of notices. It's not of delivery of the contract or any sort of back and forth negotiations that are done via email, correct?
So it's for notices or addendums after ratification. Nothing in here is for prior to ratification. No terms in here apply before ratification.
Okay, so if the listing agent is putting their email address and the seller's email address, anything must be delivered to those addresses, correct?
Technically, yes.
Okay, thank you.
You're welcome. Okay, section
Actually, I have a
7.
question.
Oh, yes, go ahead, Veronica.
Thank you. So this is everything after the ratification. So before the ratification, we still need to follow the MLS, required to send the offer, right?
Yes.
Okay.
Yes.
Thank you.
So section 7 is just really a link to the Residential Property Disclosure Act and a reminder that the property is being sold as is, except otherwise agreed to in writing. Okay. The next 2 sections are regarding HOAs and condos. and they're essentially the same. There's a paragraph embedded from the statute that talks about what the rules are, okay? And they're both essentially the same. So you're going to check, is the property in an HOA, yes or no? And then the next section says, for delivery of the HOA packet, there's a blank if it's electronic and a blank if it's a hard copy. So here's where there's a difference from that previous delivery paragraph. Here is where you put your email address and your client's email address in that electronic section. And in the hard copy section, you put your client's your client's home address or wherever they want the hard copy delivered. Okay. The hard copy does not come to you. It goes directly to your client. But the electronic copy goes to you and your client. Now, let's talk about this for a second as far as the logistics of the delivery. Previous versions of the contract from years ago allowed the buyer to decide how they wanted to receive it. Did they want to receive it electronic or did they want to receive a hard copy? Well, now it doesn't matter what the buyer's preference is because the seller orders it in most cases ahead of time, and maybe the seller has a hard copy. And so that's what they're going to deliver. So here you have to fill in both lines, okay? Because you don't know at the time of your offer what version of those documents your client is getting, okay? So that's one thing. The review period for these documents is 3 days from delivery of the documents, not 3 days from receipt of the documents. So for those of you that have been in the business for a long time that have looked for the document that used to exist, that was the receipt of the HOA or condo docs, it doesn't exist anymore. It was removed from the forms library because receipt is not relevant. It is delivery. So if a hard copy of the HOA docs is delivered to you and you don't know that it's been delivered and the 3 days passes, then your client is out of luck when it comes to having a review period that gives them the option to void. Up until 3 days after delivery, the buyer can void with no penalty this contract and get their earnest money deposit back. Okay, so up until 3 days after delivery. So they don't have to have actually received the documents to use this paragraph to void. So you see buyers all the time that do a home inspection with right to void only, and there's something big that comes up, they don't void, they're thinking about it, whatever, and that elapses, and then they end up voiding on HOA docs, right? Or they've done this for information only, whatever that was, home inspection, and then they try to negotiate because they have the out with the HOA or condo docs.
Shannon, is it 3 days from delivery by email, or 3 days from delivery of the hard copy?
It's 3 days from however it's delivered.
Okay.
So if it's sent via mail, then it's different, right? But if it's hand delivered, right, then it's 3 days from when it's hand delivered. So when you have a situation where a buyer needs more time to review the documents or to reach out to the association for clarification on something, the statute was updated in October, I believe, of 2020 to allow an additional 4 days. So it's a total of 7 days for review. Prior to that, you couldn't negotiate additional time to review. This was one of the things in the contract that was not negotiable, right? Anything that's statutory is not negotiable. So now there's a document that I have included that we will look at later that is signed if the purchaser wants to extend that review period for any length of time after the 3 days up to the 7. So it can be 1, 2, 3, or 4 additional days for a total of 7 days. The other
But
key-
Shannon, sorry, but that decision needs to be made upon writing the contract. That extension, it isn't, I mean, it could be, but isn't typically negotiated once you get the docs, correct?
It is typically negotiated once you get the docs. A buyer
Okay,
doesn't
thank you.
know until they see the docs that they need more time to review them, in most cases. In a few cases, the buyer might know that they have a unique situation, and so they want to have the full 7 days because they know they're going to have to do a little research in it. But in most cases, it's not until after they get the documents and they're unclear on whether or not they can do something, or they want more information that they need that extension. The
Does the
buyer,
seller have to give them the 4 days?
I'm sorry, what was the question, Pam?
Seller have to give them the 4 days, or is it
No.
negotiable?
It's negotiable. The buyer, by statute, cannot waive their review period, their initial 3-day review period. So I have seen in many contracts where a buyer tries to make their offer stronger by saying that they waive their 3-day review period. That's not enforceable because it's statute, and it says right here in the contract, the last sentence of the statute where it's copied, it says the right to receive the association disclosure packet and the right to cancel the contract cannot be waived. I'm sorry, it says that they're waived if they're not received by settlement, but the sentence says that they cannot waive their rights under this section. Where's my sentence? It's in here. We'll find it. I'll find it later. But it is statute, so they can't waive it. It's not a negotiable term. So even if they say they're going to waive it, and the seller says okay, and they take them, it doesn't matter. They still get the right. Gailey.
Just a question. Have you seen this happen? Have you seen people request this and sellers refuse to negotiate this? Or do you find that sellers are kind of open to it?
I find that sellers will agree to it because what will happen if they don't is the buyer will just void.
Right.
And usually the buyer's side will tell the seller side what information they're looking for, right? So that they know that that they're not just playing a game, trying to delay for some other reason. Like if it's legit, then it's, they're going to agree to it because their risk is that they just void. All right. Property maintenance, condition, and inspections. Okay, this
And
section.
sorry if I interrupt you. I raise my hands. Question about just to be sure if I understand correct, because I always was confused about that. So it says here electronic and understand 3 days by email, right? And it says hard copy. So hard copy means that you need to physically bring the package and bring at buyer's home, right? Because you put the client address. So when it's going to be mailed, that I understand. That let's say it's going to take longer, something happened, he says no, so it's not going to take 3 days, right? But it's going to take longer, let's say 5 days. What happened? This I understand, I'm sorry.
So I'm not sure I understand the question. So if it's emailed,
Mhm. It's okay.
then it's delivered electronically, and it's whenever it's delivered. If the seller has received a like a binder
Right.
from the HOA,
Mhm.
and it has to be delivered, then whenever it's delivered to that address,
Mhm.
if it's physically delivered, is
Mhm.
like dropped on their front porch or dropped at their office or whatever, that's when the 3 days starts.
Yes.
So it
but
doesn't
if it's-
matter if it snowed between when it ratified and when they, get the HOA docs. It's 3 days from delivery. Now, if you put your own address or the office address for delivery of the hard copy and it's delivered to the office, and then there's a problem where you can't get those documents to your client to review, then that's a big problem because they now don't have their review period. And that's also why I said don't ever put your own address there.
Yeah, but let's say if the client says, I didn't receive the package, and it passed a long time, and the seller says, I sent the package, but you know what I mean? The client didn't receive. It has to be approved, right? If it's a mail.
Yes, the seller has to prove that they sent it. So whoever sends it, it's 6 days from the postmark,
Mhm.
okay, for review, or 3 days from hand delivery.
So when you do hand delivery, that's what I understand. Mail, there is a tracking. But if you do hard copy and you put outside of the porch, let's say, do you need to take a picture? Do you need to do something to show that that day, at that time, you was there?
Yes.
So you need to take a picture.
Yes.
Okay, perfect. Now I understand. Thank you.
Okay. Moving on to property maintenance and condition.
Sorry.
Yes.
When they are delivered, is that day 1? And then day 3 ends at that moment time?
The delivery is always day 0.
Okay, so day 0. So say it's Friday at 3:07, right? Saturday's day 1, Sunday's day 2, Monday is day 3. When does day 3 end?
11:59 p.m.
11:59. Okay, cool.
Yep.
Thank
Yep. So remember, 9 p.m. applies to everything except for HOA and condo docs. So when we're talking about ratification date is day 0. All of our timelines, that delivery date is day 0 for purposes of counting your days. Property maintenance and condition. This is how we figure out what inspections are happening or not happening. So except as otherwise specified, the seller will deliver the property free and clear of trash and debris, broom clean, and in substantially the same physical condition as of the date of offer or date of home inspection or some other date. And if no date is selected, then it defaults to the date of offer. Okay. So let's break this down a little bit. Free and clear of trash and debris means all the trash, all the stuff out of the house and out of the garage and off the property. Okay. The property is not just the inside of the dwelling. Okay. It's the land as well. Broom clean means they did not have to hire their cleaning service to come in and scrub the inside of the oven or the inside of the refrigerator. If they did, that is a do unto others, right? We would all like that to have happened. And that is not what our contract lays out, okay? In substantially the same physical condition applies to things like holes in the wall and minor things like nails in the wall versus a hole and whether it has to be spackled and painted. Okay, so I'm going to tell you that the general rule of thumb is if there were pictures on the wall and there were nails, you take the pictures off and you leave the nails in, that's substantially the same condition because the nails had been there. If you take the nails out and there's a whole bunch of holes that haven't been spackled and painted, that's not substantially the same condition. Okay, this also applies to things like damage or systems that aren't working. So regardless of whether there's a home inspection, the home has to be delivered in substantially the same condition. So let's say the hot water heater dies 3 days before closing. There was no home inspection. Seller has to replace the hot water heater because the hot water heater was working prior to that 3 days before closing. Okay. Now, let's say the hot water heater was never working properly and the buyer waived their home inspection and they come to do their walkthrough and they say, well, the hot water heater's not working. Well, there needs to be proof somewhere that it was never working, right? So this is when disclosures are very important because if your seller discloses that the hot water heater's not working and the offer is made, and then the buyer tries to come through a walkthrough and say the hot water heater's not working. Well, okay, great. You knew when you made the offer, right? That's not a walkthrough. Now there's a choice here between date of offer and date of home inspection or other. So let's talk about other for a minute. Very rarely would you use other. Okay, other is saved for a situation where like an investor is coming in and buying a property that is maybe a distressed sale. And so they really don't care what the condition is. They just want the seller to move out and they really don't care what the condition is. Okay, or like a tear down or something, right? Like they don't care what the condition is. So almost never will you check the box of other for your client. Date of offer and date of home inspection are interchangeably used, and there's different thoughts behind date of offer and date of home inspection. I will not be upset with you if you use one over the other. There's a reason in here that date of offer is the default. I prefer date of offer over date of home inspection. And I have a couple of scenarios for why. Steve Gaskins prefers date of home inspection. We'll explain why he prefers date of home inspection. And it's okay that he and I don't agree because I respect the reason that he has date of home inspection as his preference. And he respects the reason that I have date of offer as mine. And as long as you are explaining to your buyers what it means, then you're okay. All right. So let's go with date of offer first because it's listed first. I choose date of offer because that is the most recent time that your client has seen the home and has their expectations set on what is supposed to be happening. Okay. I also choose date of offer because if something happens between the date of offer and subsequent ratification and your home inspection that does not get agreed to in writing as far as a repair to happen, it is still binding in most cases. Here's an example. You have a summer storm that comes in and rips a bunch of siding and shingles off of the home that your client is purchasing. Okay. You have put date of offer. At the date of offer, all the siding was there, all the shingles were there, everything was perfectly fine. Okay. Seller says, we're going to go ahead and contact our insurance company. They're going to take care of it. We have plenty of time before closing. Everything's going to be fine. okay? You go do your home inspection. Nothing else is wrong with the house. Everything else is exactly like it was supposed to be, because your home inspection was with right to void only. Your client's like, okay, great, right? It's noted that the shingles are missing and the siding has come off, but we're moving forward because it's right to void only. You get closer and closer to closing, and you as the buyer's agent reach out to the listing agent and say, hey, what's going on? We see that the roof and siding hasn't been repaired yet. When can we expect that to happen? And they say, oh yeah, about that. The seller decided not to do it because their deductible is $7,500 and they really just don't want to pay it. Okay, so now what? Well, at date of offer, remember, the siding and the shingles were fine. So they are contractually obligated to deliver the home in substantially the same condition. So contractually, they need to pay their deductible or pay out of pocket and have the siding and shingles fixed. So in that same scenario, date of offer is not checked, but date of home inspection is checked. And same storm happens. You don't negotiate in writing. They say, yeah, we don't want to pay the $7,500. Your buyer's out of luck because of date of home inspection. Okay. So that's my story about date of offer. Now, let's go to date of home inspection. So at the offer time, you don't have record whether the systems actually worked. You don't have additional photos of certain things because you're not taking photos when you're going through the home. So Steve likes to have date of home inspection because you have actual record of the systems and what their condition was at the time of the home inspection. You have photos, you have actual record. Now, there has been some discussion back and forth about what would a judge say about whether a system that wasn't working at the home inspection, right? If it said it was not working at the home inspection, or was working at the home inspection rather. Let's say it's the hot water heater again, okay? The hot water heater is working perfectly fine at the home inspection. Is it not working at the date of offer and then magically works at the home inspection and then is not working at closing, right? The likelihood that a system or things inside the house are working at the date of offer and not working at the home inspection or is very, very low, right? Or vice versa, right? It's not working on the date of offer and then it works at the date of inspection and then not later. So either one's okay. I like date of offer, even though we don't have the additional pictures and things at that point from the home inspection, it still covers that extra period of time between when you saw it and when you get in the house, okay? The other thing is if you have no home inspection, then you have to choose date of offer because there's no home inspection. All right, questions on that section. I see 2 hands raised. Let me find the hands that are raised. Pam, you have your hand raised?
Yes, I do. I had a question. What about the seller removing fixtures and things like that? And, prior, because it may be the home inspection, they come back and, they may have changed out light fixtures and stuff like that. How does that apply?
Yeah,
as
so
opposed to doing
yep, that's a great point. So another thing that I like about date of offer versus home inspection is, for that example, right? Light fixtures or even appliances sometimes. I had a seller who had a refrigerator break. And it had been a nice high-end stainless steel refrigerator. And she was like, can I buy a cheap white refrigerator to go in? And I said, no, you have to buy one that's substantially the same to replace the refrigerator to go in, right? Because we had date of offer on there. So changing things between the date of offer and the date of home inspection is something that can happen. That's also what protects you from things being swapped that your client saw, even if it didn't break, between offer and home inspection, just because they didn't get a chance to, they wanted their grandmother's chandelier from the dining room and they didn't have a chance to swap it out ahead of time and they didn't mark it in the contract. So they're like, oh, here, we're covered. We'll just swap it before the home inspection, right? Khan, you have a hand up.
Yeah, so if there was, so back to the like home offer or home inspection, if you don't have like pictures or something and you did time of offer, like would just seeing something be enough to be like, okay, well, we saw this, or like we checked the lights and they did work then or something? Or would you need necessarily like pictures or something, or like kind of like notes?
Yeah, so what I always suggest, because we do ask for the MLS printout with our compliance, do the page also that has the photos from the MLS, because almost always you're going to have photos in the listings that you're going to see. So print those photos, and that's going to be helpful. I had a call a couple of years ago on Christmas Eve. I know, can you imagine? I get calls on Christmas Eve. At least they don't call on Christmas Day, I guess. That was from an agent who had a walkthrough issue from her client who was closing the day after Christmas. And the question was about some stain on the wood floor, okay? And swore it wasn't there during the home inspection and whatever. Well, it's not really a home inspection item, right? I flipped through the pictures in the home inspection. I didn't really see where this area was, but I went back to the MLS and I pulled up the MLS photos, and sure enough, I found this stain on the floor in the MLS photo. And I said, I'm sorry, but it was there because I can see it in the MLS photo. So our buyer just didn't remember it. And so they had to, take that off their walkthrough issue. So the MLS photos are, even though they can make homes look nicer than they might present in person, you can still see some things as far as condition, right? You can see whether there's a hole in the wall. You can see whether the floors are scratched and things like that. And if there's something major, ask the listing agent if you can take a picture when you're showing the home, right? Or before the offer. All right. The next little part is that the contract is contingent on the home inspection or other inspections, right? So home inspection, radon inspection, well and septic, any other inspections, or the buyer waives the opportunity to make it contingent on inspections, okay? If the contract is contingent on the home inspections, then the seller will provide the broker, which really is you guys as the agents, and the buyer and the inspectors reasonable access to the property. So we're going to get into this a little more on the home inspection addendum. But what this is saying is inspections, meaning you have a 7-day home inspection, and on day 3, you have your home inspection, and the inspector says, hey, you might want to get the roof checked out. Well, you're allowed to come back on day 5 with your roof inspector. Okay. So we'll talk about that in more detail when we get to the contingency. This next paragraph is new. This next paragraph is to address these home inspections for information only. So that nonsense that was happening is addressed here. So what it says is that if this contract is not contingent on the home inspection or any other inspections of the property, the seller will not provide access to anyone for the purpose of conducting inspections unless it's the walkthrough inspection or as provided below. So if the box is checked that's here in bold, this is where you're activating that for information only inspection, okay? However, if the box is checked, the seller will provide broker, buyer, and licensed professional insured inspector retained by buyer reasonable access to the property to conduct home inspections or other inspections of the property beginning on blank and ending on blank. Okay, why do we have a beginning and end? Because the home inspections for information only were set up in a lot of cases where sellers did not want these inspections done until after the HOA docs were delivered and after that 3-day review period happened. So that when the buyer said, hey, we are going to waive our contingency on inspections, but we just want to come in and do an inspection. Well, really, you should just wait until after closing and do your inspection if that's truly what you're doing. They knew that the buyers were playing games and they were saying, look, we want to get in right away and do an inspection for information only, and then we can use that HOA right to void as a negotiating tool if we find something. So what this does is it says, hey, we're going to negotiate that we want to come in and do that inspection without the right to void or negotiate anything. And here's the time frame that the seller is going to allow them in. So they might not let them in until near the end. They might let them in the beginning. They might say after the appraisal or after the HOA docs are delivered. So there's a beginning and end period here. Okay, so we tried to provide in this paragraph, we tried to address all of the scenarios that we were seeing written into the additional terms section that weren't really enforceable and really didn't protect the clients. Okay.
Shannon, if we
Yes.
wanted to say after appraisal, I know you don't like us putting words instead of numbers when it says, you know, you should put numbers in. So that those gaps to me look like they're looking for specific dates. But if we're saying, for instance, after appraisal, can we cross that out and say after appraisal? Because the appraisal might be 5 days, it might be 2 weeks. So you just do it after the appraisal contingency period is over if there's an appraisal contingency.
So I would do it after the appraisal contingency period, or I would put target dates and tell your seller you might be stuck with that right there. But you know, again, it depends on if you're worried about the appraisal. But if you are worried about the appraisal, then I certainly would do it after the appraisal contingency because you would have that date already in your contract. The next paragraph says, regardless of whether the contract is contingent on inspections, the seller will provide the broker and buyer reasonable access to the property to make walkthrough inspections within 7 days prior to settlement or occupancy. Okay, so I want to talk about this for a second, and then I'm going to let you guys break for lunch, okay? So this part is twofold. We've had some situations, and I'm actually going to stop sharing so I can see all of you because I like to see all of you. There's been a lot of confusion over the years on whether or not inspectors can come back with the buyers at the final walkthrough to check things. The previous iteration of the contract said buyers and their representatives, right? Well, the representatives were meant to reflect their agents, not inspectors or their parents or their brother-in-law who's a handy homeowner. It was meant to be the agent as their representative because that's what is indicated in the contract. So we clarified the language there that said that the buyer and their broker, right, or agent, right, get to go for the walkthrough inspection. On the inspection contingency removal addendum, which we will address later this afternoon, there is a place that says that if there are repairs negotiated, the buyer can bring back the inspector to check the items that are listed on the HICRA. So what was happening was buyers were waiving their inspections and then using the final walkthrough as an opportunity to bring an inspector back with them and check things that then they tried to negotiate credits or escrows or things on the walkthrough. There's a lot of funny business that happens out there, okay? And if you haven't encountered it, be very thankful. And the longer you're in the business and the more transactions you do, you will run into something like this, okay? Real estate is not dull. So, no inspection contingency means no, or actually, no HICRA items negotiated means no inspector comes back at the final walkthrough, only when HICRA items are negotiated, okay? All right, 1242, I'm gonna stop right there. We got through a lot, right? That was a lot of like.
Shannon, can I ask you something?
Yes, I'm gonna open it up for questions and then I will let us break for lunch. So Z,
Thank you.
go now.
So, two questions. Can you please go back to where it says property beginning on and ending on? Nothing in this subparagraph creates contingency.
Yes,
I'm a
so
little
that's-
confused about that part. And the other thing is, after the inspection is done, with some of the clients that I've had, they have asked me to go back to the property and to measure some things for the furniture and stuff like that. Does this paragraph mean that I'm not gonna be able to do that anymore?
So you never had a contractual right to go back in to measure and do things. It was all about whether the seller would allow it, and the seller can still allow you to go back in and measure, or
Okay.
That's still up to the seller. The paragraph that you're referring to, where it says blank and ending on blank, in a regular home inspection contingency, it says that the buyer has until blank days after ratification to do their inspections, okay? What that paragraph here is saying to us, because there's no contingency, is that it's not blank days after ratification, it's between a certain window of time that they can go in with their inspector. So it's not up until 7 days after ratification. It actually might be days 15 through 18. And so you're giving them the actual dates that they can go in the property. Or it's just simply the dates that work best for the seller, right? Because it's not a contingency. So the seller's like, all right, I'm going into my office to work on, the third Monday, Tuesday, and Wednesday of our contract period. So I'll give you those days. You can do your inspections those days because I'm already not home.
Okay.
Okay.
So this only applies when there is no inspection contingency.
Correct. It's when a buyer wants to come in and do inspections without a contingency.
Perfect. Thank you.
You're welcome. Any other questions?
Yes, so let's say if I make an offer for my client and it's not contingency up to home inspection, how many days you recommend? Like, first of all, do I need to call the listing agent and ask to him what the seller prefer as a date? And how many days do you recommend?
Okay, so if it's not contingent on the inspection, okay, my My real answer is I prefer you not do it at all, because if it's not contingent on the inspection, then it doesn't matter what the results are, and it shouldn't be done.
Okay, but if you say, if you have a client that says, yeah, I just want to know, it happened, right?
Then it depends on the scenario. So there isn't a standard, because I am not encouraging it to be done.
Okay, so you
Okay.
say, so what would you say to the client when they ask you, no, I still want to know, just for my curiosity, I know we make an offer that is not a contingency of the home inspection, but I just want to know, I'm curious now if we did good,
Yeah.
if not, and if it is a major thing that, doesn't work. So,
But it doesn't matter if it's a major thing.
I know,
right?
but if you find the client is, I'm curious, I want to know, what do you say to the client? What do you recommend? What do you,
Well, at
get
that
them
point, I
involved?
would recommend doing a home inspection with right to void only, and doing it within the first 3 days of the ratification period.
But if
If
they say,
they, if
if
they
say,
really want to know, that's what my suggestion is.
yeah, but if they say, in order for to win the offer, especially now in this market, the listing agent says, I have other offer where they waive the inspection. So in this case, I need to disclose to my client what the listing agent told to me. Then it's up on their decision what they want to do, right? And let's say the buyer say, yes, I want to do without the home inspection. Then later they come to me and they said, for curiosity, we want to see what's going on.
So in that case, I would call the listing agent,
Okay.
and I would ask them what they would want in there. Or I would check the box, and I would tell the listing agent to fill it in.
Great. Sounds good. Okay. Thank you.
Yes. All right. Any other burning questions before you guys pass out? And I don't mind if you're eating while I'm teaching. So if you guys, want to sustain yourself through the afternoon and not go into a huge food coma by eating a lot during our lunch break, I'm good with that. Okay. It is 12:48. I would like to have you guys back at 1:20 for us to resume. So if it means that I get to see what you're eating for lunch, bring back what you're eating for lunch. And we're gonna go through some more stuff. I will try to remember to give you guys breaks. I'm hoping that because most of you are in the comfort of your homes. Fredericksburg, I love the fact that you're in the office. I can see you there on Allie's screen. Yay. Thank you for being in the office. I hope that you all are comfortable enough that if I forget to give you a break, you'll just get up and go to the bathroom. Okay. But I will try, because it's a lot. It's a lot. Okay. 1:20. See you soon. All right, it is 1:20, so it is time to gather everybody back on screen. Show me that you are here. You're gonna get to see what I was eating for lunch real quick before we get started. All right. Well, hopefully the more than just what I see on screen are back, but we will get started anyway, because all of you are here on time, so I appreciate that. We are going to pick up where we left off in possession date section, which is section 11. So the possession date paragraph just talks about how the seller will turn over possession at settlement to the buyer. So Virginia is a wet settlement state. We touched on this on Monday, which means when the ink is still wet, right? That's where they get that from. The transfer happens. It doesn't happen once the deed is recorded. It happens at settlement. So delivery of keys, mailbox keys, key fobs, any codes like to garage doors and things like that get transferred over. We did add mailbox keys to this, and the seller is only transferring over what they have, right? So if the seller doesn't have mailbox keys, then they can't give them, right? The seller is not required to go and make extra sets of keys, etc., if they don't have them. The seller also has to transfer exclusive control of smart devices, right? Like the Nest thermostat, a Ring doorbell if they're leaving it. We had to specify these things, of course, because sellers would not turn over their Nest or other smart device for the thermostat, and the buyer had no control over the heating and air conditioning in their home. Okay. If there's a post-settlement occupancy or something like that, then the post-settlement occupancy agreement provides for the fact that the seller gets a key at settlement. Okay. Utilities. We're marking what the utilities are that are in the property. So is the water on public service, or is it on a private well? Is it a community well? Hot water? Is it heated by oil, gas, electric, or other? Same with heating and air conditioning. There's a section to put how many zones. This is very similar to what you saw on the listing agreement, and we should be getting this information from the seller. If we are a buyer making an offer, it is on the listing information sheet. It also would be included in the listing in the MLS if it's filled out properly. Conveyances. This section is just like the listing agreement. So it talks about what conveys and what doesn't. So this is where we get lots of confusion about what are window treatments and what are not, what automatically conveys and what doesn't. So just to reiterate, anything that's physically attached to the structure or to the land automatically conveys. So this means trees, shrubs, window shades and blinds, because they're a one-piece unit that's physically attached. Those convey. Window treatments, which are curtains, don't automatically convey, but the curtain rods would, because those are attached with their hardware. If you have a client who has TVs mounted to the walls, talk to them about that, because the mounts automatically convey, but the TV itself does not. So if they don't want the mounts to convey, then they need to understand that when they take the mounts down, they have to patch and paint. They cannot just leave the hole from where the mounts were. And that is something that would be indicated in the does not convey section down here. So it's clear that the mounts are not there. Okay, if the buyer does not want the mounts, This is also where the buyer would say, hey, take your mount. I don't want your TV mounts. This section was changed from the previous version of the contract. So there is no more yes or no. It's simply yes, if it's there and is being offered. We talked about this other conveyances, as is no additional value for seller convenience. What this is for is so that the lender doesn't come back and say, take it out of the contract, or give us an addendum saying there's no value for things like a pool table or, you know, pool furniture or the riding lawnmower or whatever, the basement furniture, whatever they're leaving. Okay. If there's something that's in the home that does not convey, you would highlight that in the does not convey section. So we use the washer and dryer as the example on Monday. So if the washer and dryer is in the house and hooked up and the seller really wants to take it with them, then you would mark washer and dryer here and does not convey. There's a place to indicate everything.
Shannon?
Yes.
Here it applies what we spoke on Monday, right? If we only have one ceiling fan, we don't put the number 1, we put something that is over 1, right?
That's correct. And this is the same, it's copied and pasted from the listing agreement. So it's absolutely the same, this section right here. So this last sentence says if more than one item conveys, the number of items is noted. So if it's just one, you don't put any number. It's only if there is more than one item. Fuel tanks. Fuel tanks are noted here. So that's like the propane tanks that we talked about. Is it leased or is it owned? And the lease is super important because remember, when there are leased fuel tanks, there's generally a requirement that the fuel is also purchased through the company that the tank is leased from. It also states here, unless otherwise agreed to in writing, any of the fuels remaining in the tank become property of the buyer. So if the seller, you know, goes and has it refilled right before going on the market and expects the buyer is going to pay them for what's left in the tank, it has to be agreed to in writing that the buyer is going to pay them. They can't just expect that there's going to be some adjustment made on the settlement statement automatically. Raekwon, you have a question?
Yeah, just a quick question for the back to the conveyances for the garage. Like, so I know you said if there's only one, then just like leave it blank, even for the garage piece, because sometimes people expect for it to be 2. For like garage remote, same garage remote.
Yeah, so if there's only one remote, then you wouldn't put anything. If they have 2 remotes, then you would put 2.
Okay, just verifying. Thank you.
Okay, service contracts would be written down in this section as well under the leased items. So anything that conveys to the new owner. Okay. FERPTA. So this is where in the contract, it is disclosed if FERPTA applies, because remember, even though we're disclosing whether the seller is a foreign person for tax purposes, it is the buyer's responsibility to make sure that the money is withheld. So it's important to all parties to make sure that this is filled out properly. So if you don't have information in an optional listing information sheet from the listing agent, you can reach out and ask what applies here, or you can leave it blank and let them know that they need to fill it in as a counter offer for you. Smoke detectors. This is a very vague paragraph. And the reason it's vague is that each jurisdiction can have different requirements. So it just says the seller will deliver property with smoke detectors installed and functioning in accordance with the laws and regulations. Okay, so if you have questions about what's required near the property, if you're a listing agent, You can go online, you can reach out to the local fire department. They will help you. Sometimes the local fire departments will actually give you new smoke detectors.
So Shannon, what if, I'm sorry, what if the home that is being purchased requires smoke detectors, but it doesn't have them? Does the seller need to pay for it?
Yes, they need to be installed and functioning. It's not just
Okay.
pay for it, it's the seller needs to install them and they need to be functioning. Okay. Lead-based paint. So lead-based paint disclosures, again, we talked about this on Monday, anything that's built prior to 1978, so not in 1978. If it's prior to 1978, then there is an additional disclosure that is provided to the buyer prior to ratification. So you're going to mark off in here whether it was or was not. And if it was, do they waive their right to a risk assessment or inspection for the lead-based paint hazards? Okay. Wood destroying insect inspection. Okay. This section says, will there be a pest inspection? And if so, is the buyer directing it at the buyer's expense or the seller at the seller's expense? Whoever is directing it is furnishing this report from a licensed pest control firm that is dated no more than 90 days prior to settlement. So this can't be from a year ago. It has to be 90 days prior to settlement, showing that all dwellings and or garages within the property, excluding fences or shrubs that are not abutting the garage or dwelling, are free of visible evidence of live wood destroying insects and or free from visible damage. Okay. There was some clarifying language that was added to this paragraph. If the wood destroying insect, so we're talking about termites, carpenter bees, those types of things. If the report recommends treatment and or repair, the seller will provide buyer, broker, and any representatives appropriate, reasonable access to the property to do the repair. Any treatment and or repairs for the damage identified on the report will be made at the seller's expense, and the seller will provide written evidence that this treatment and or repair has been done prior to settlement. All treatment and repairs are to be performed by a contractor licensed to do the type of work required. Okay. So what does this say here? It says that the property has to be free of visible evidence of live wood destroying insects and free from visible damage. So there can't be damage and there can't be any live evidence. So if there is damage that's not visible, then there's nothing to be done. And if there's live insects, the seller must remediate. Okay, any questions on this paragraph? Because I know that this gives people a lot of heartburn.
Shannon, it's Anna. I do have a question. So this is a while ago, and I had a home inspection, and the home inspector saw signs of termite damage. Then the seller had a contract with a termite company, and they had them out and gave it a clear termite report. So the termite inspection said it was clear. The home inspection said there was previous damage, not signs of live insects, and he is not a termite inspector, so therefore not a specialist in that area. How do you proceed? Like the termite company says, no, there isn't, they're fine. But the home inspector says, well, I see damage.
Also, if the home inspector is not a licensed pest inspector, then it doesn't apply here. If the licensed pest inspector says that there is damage from wood destroying insects, then the damage needs to be fixed. That's what's automatic in this.
Okay, and so in that situation, the seller had engaged the pest control company who said there was no damage. If the buyer would want to say, I want to pay for another inspection just to get a second set of eyes, given the conflict of story, what was being reported, what's the situation with regards to getting a second opinion and kind of bringing that into the mix.
Well, what does the contract say?
It talks about a licensed pest inspector. I'm on my phone, so I can't.
Well, it sounds like in that situation that it says the seller will provide.
Oh
the
yeah, sorry.
report.
Yeah, no, and it was a VA loan, so it had to be the seller. There wasn't a choice as to who was going to pay for a termite inspection.
Right. So if the buyer wanted to have another inspection done, then they can, but there's no consequence to the seller if the buyer has another inspection done. Because it's the seller at the seller's expense that's furnishing the report. So it doesn't matter who the buyer has come in.
Okay, thank you.
Okay. The next section is on home warranties. So yes or no, is there a home warranty policy? And is the buyer choosing it or is the seller choosing it? And who's paying for it, the buyer or the seller? Cost not to exceed blank. And who is going to be the warranty provider? You as the agent are not a party to this contract. Putting in buyer's agent or listing agent will pay for this home warranty is not enforceable. So don't do it. You are not part of this transaction. If you are going to pay for something on behalf of your client, it has to say that your client has the responsibility for it, and then you have an agreement with your client outside of this contract. This contract is between the buyer and the seller. You are not a part of it, okay? So if you are the buyer's agent and you are going to buy a home warranty for your purchaser, then it would say that yes, there is a home warranty, it is chosen by the buyer and is paid for by the buyer. And then you can buy the home warranty and send your receipt to the title company, and it would show as paid outside of closing. Okay. Damage or loss. The risk of damage or loss remains with the seller until settlement. So they have to keep their homeowner's insurance on the property up until settlement is what this says. Paragraph 20, the title paragraph. So this is one of those paragraphs that, you know, there's a whole bunch of those catch-all paragraphs towards the end that we really don't ever look at, but the title paragraph is an important paragraph. So this one has a couple of different things in it. One of them says that the buyer will promptly order a title report as well as any required or desired survey. So what does this mean? This means that you're going to send the contract to your settlement agent, your title company. They're going to open the file and they are going to start processing everything. You're not going to wait until 2 weeks into the process. You have to, as the buyer side, actually request the survey. It's not going to be done automatically. You have to request that you want a survey. The home will be sold free and clear of liens, except anything that's going to be assumed by the buyer. The seller will convey title that is good, marketable, and insurable with no additional risk premium to the buyer. In case action is required to perfect the title, the action must be taken promptly by the seller at the seller's expense. So what happens if there's an issue? The seller has to remedy that. So the example that I gave you guys on Monday was about the client that I had years ago where the husband and wife and brother were the owners when my client bought, and the brother never signed anything. And so there was an issue. Well, the seller had to pay for the services of the title company to track everybody down and re-record, okay? If there is any error that's on title that has to be fixed or, you know, anything, it's the seller at the seller's expense so that the seller can convey clear title. It's giving a warning to the buyer that the title may be subject to easements or covenants, conditions, or restrictions as of the date of ratification. So this is a clarification that it's as of date of ratification. It used to say as of date of settlement, and this is to prevent any like deed restrictions or any easements being placed on the property after ratification that the buyer didn't know about up until settlement. So this was changed. The seller is going to convey the property with a general warranty deed. The manner of taking title may have significant legal consequences, so the buyer is advised to seek the appropriate professional to talk about this. So the buyer would talk to the title company and maybe their accountant or their own attorney about how they should take title. So there are, if they're an individual, then they'll probably take it in their own name. There are ways to take title in a trust. If they're buying it in a business, they could take it in the business. If it's a married couple, they have the ability to take title as tenants by the entirety. You can take it as joint tenants. There's right of survivorship. So there's different ways to take title, and you are not the expert on advising a client on how they should take title. So that's one of the things where you can refer them, right? You should know enough to know what questions they should be asking someone else, okay? Seller will sign affidavits, lien waivers, tax certifications, and other documents that might be required by the lender or title insurance company or settlement agent, etc. And they authorize the settlement agent to obtain their payoff. So this is all just, standard written in here. The approval is already there. Unless otherwise agreed to in writing, seller will pay any special assessment and comply with all orders or notices of violations of county, local authority, condo association, homeowners, or property owners association, or actions in any court, account thereof, against or affecting the property on settlement date. The broker is hereby expressly released for all liability for damages by reason of any defect on the title. So, this means that the seller has to clear all of their violations, if there are any. So this is something that is in our listing consultation when we talk to our clients about whether or not a home is being sold as is, whether it's a home inspection for information only. What does that mean when it comes to HOAs versus home inspections, right? HOAs are liens on the property. So any violations have to be taken care of before settlement. And we have to make sure that they understand that ahead of time. Okay. Special assessments are also another thing that's very interesting, because sellers think that because an HOA gives a payment plan on special assessments, that it conveys to the buyer. So if a special assessment has a due date, right? So the special assessment is on assessed on January 1st. And so it's due January 1st, and sellers can make payments over time, then it's still the seller's responsibility, okay? Because it had a due date. Now, if it's a special assessment that is something added monthly, that's assessed monthly, then the monthly payment does convey to the buyer. But if it had a due date in a lump sum that's just given a payment plan, then it does belong to the seller. Pam, question.
Can that be negotiable in the contract?
Well, it says unless otherwise agreed to in writing. So a seller might say that the
okay,
buyer
great.
has to credit them for it. Yep. Okay, notice of possible filing of mechanics lien. So this is something that is a notice to the buyers that says that the anybody who does work on the property has up to 90 days from when they did the work to file a mechanics lien, and it gets attached to the property, not the person. Now, a seller is signing a document at closing saying that they don't have any unpaid work outstanding, but this is a risk that is out there, so it's a notice. Okay. Fees for preparation of the deed. So the fee for preparation of the deed is billed to the seller, and costs of having the encumbrances released, right? You'll see lien release fees and things like that on a settlement statement. Seller's legal fees and other charges are paid by the seller. There's title exam, survey, other fees that go to the buyer legal fees, and other fees that are appropriate to the buyer go on their side. It also talks here about grantor's tax, congestion relief tax, WMATA tax, capital fees that get paid by the seller, and these are generally itemized out separately. Okay, and buyer pays the recording charges for the deed and recording charges for the mortgage, right? Deed of trust and note. Okay. Broker fees. This is where you get paid. The seller instructs the settlement agent to pay the broker's compensation directly. Okay, so we're not chasing down a seller to pay us. It's coming right out of their proceeds, and the settlement company is paying us. Okay. Adjustments. It's just making a note that there are things that are prepaid or not paid that get adjusted on either side of the settlement statement. So this is very common with personal property tax. When it comes to real estate taxes, this could be water bills, HOAs. If you pay your HOA fee on the 1st and you close on the 15th, then you've paid the whole month. So the buyer needs to reimburse you for the rest of the month. This is similar with taxes. If you are escrowing your taxes, which almost everybody has to if they have a mortgage, and you are closing in April and the first half taxes aren't due till June 1st, you're going to be paying at settlement as a buyer. I'm sorry, as a seller, you're going to be paying January, February, March, and part of April. And then you're going to be getting money back from your escrow company. Okay. Attorney's fees. This is just like what we saw on the listing and buyer agreement. Whoever the substantially prevailing party is gets their attorney fees paid by the other side. Default. Okay, if a buyer fails to complete settlement for any reason other than default by the seller, buyer will be in default, and at the option of the seller, the deposit may be forfeited to seller as liquidated damages and not as a penalty. Okay, so I talk about this a lot, where if a buyer defaults and then there's no contract and the seller wants to go back on the market and the buyer doesn't release their earnest money deposit to the seller, right? So the money's just sitting in escrow, and the seller is able to resell the home for more than what they were going to sell to buyer number 1. They sell to buyer number 2 for more. So they didn't actually lose any money. They actually made out better because buyer number 1 didn't close. They will need to sign the release and give the money back to the buyer. Okay, because the deposit is not meant to be a penalty. Okay, it's meant to cover damages. Now, if the buyer defaults, or if the buyer wants out and they're asking to be let out and they sign the release and say, please let me out, I'll give you my deposit, or I'll give you some of my deposit, and all of the money is dispersed and the release is signed and everybody goes their separate ways, and the seller resells for more, then they don't have to go back and give the money, right? That it was an agreement, it was a mutual agreement. But if the buyer defaults and the seller goes back on the market and sells for less, and the difference is more than what the earnest money deposit is, and they never signed the release, then the seller can go after the buyer for the total damages that they incurred. So if the earnest money deposit is $5,000 and they sell it for $20,000 less than what they would have sold it to buyer number 1, they can go after the buyer for more than the $5,000. Now, let's say the buyer says, let me out. I'll give you my $5,000. Please let me out. Buyer and seller sign the release. Seller sells it for $20,000 less. Well, they signed the release. So that's the limit of the buyer's liability. The buyer doesn't owe any more money. They made an agreement that the seller would take the $5,000 and take their chances. Okay, that's what this first paragraph talks about. Now, if the seller fails to perform or comply with any of the terms or conditions of the contract, or fails to complete settlement for any reason other than default by the buyer, the seller will be in default and the buyer will have the right to pursue legal or equitable remedies, including specific performance or damages. Okay, there's no specific performance for a seller to sue a buyer. Okay, it's actual damages. The buyer can sue the seller for performance or damages. Okay. If either buyer or seller is in default, then in addition to the other damages, the defaulting party will immediately pay costs incurred for title exam, appraisal, survey, and broker's fees. Okay, so all of those things, the title fee, the appraisal, survey, commissions, those are separate and third-party expenses. If either seller or buyer refuses to execute the release of deposit when requested to do so in writing and a court finds that such party should have executed the release, the party who so refused to execute the release will pay the expenses, including without limitation attorney's fees. So this is the paragraph that basically puts the parties on notice that says, hey, if I send a notice to void and it's legit, and I send the release and you refuse to sign it, and I have to go to court to get my money, you got to pay my attorney's fees. So if it's void, then they need to sign the release. It also says if this, in the next section, if the contract becomes void and of no further force and effect without default, both parties will immediately execute the release, directing that the deposit will be refunded to the buyer according to the terms in the deposit paragraph. Okay, so that's just one more place that says, hey, you have to sign the release if the contract becomes void. Section 28 just goes on to some general disclosures. Property condition. We talk about property condition a lot. It says that there are inspections and warranty insurance programs that are available, and that you as the agent are not advising the parties to certain other issues like water quality, sewer and septic, soil condition, flood hazard areas, restrictions on the covenants or zoning or subdivisions or construction materials or anything like that. Probably be laid pipes, stucco. It lists all of those things out and basically says you as the buyer need to do your own homework. Legal requirements, it talks about how all contracts for real estate must be in writing to be enforceable. This also means any addenda, right? Any additional terms that are agreed to after have to be in writing, and that means buyer and seller signing. Right? This is not negotiations that go back and forth between the agents. Once they're signed by the buyer and seller, that's when they're enforceable. It talks about financing and how mortgage rates and charges vary with financial institutions. The buyer and seller acknowledge that the broker is being retained solely as a real estate agent, not as the attorney, tax advisor, lender, appraiser, surveyor, structural engineer, mold quality inspector, home inspector, psychiatrist, Uber driver, et cetera, et cetera. Property taxes, could substantially increase after settlement. That almost always happens in new construction. They fluctuate, of course, year to year on regular resales based on how much money the county wants, the county gets. Property insurance, the lender generally requires this to get financing, so it's just putting them on notice. And the rates and availability are determined in part by the number and nature of claims on the property, right? So this is that clue report we talked about. Some properties can be uninsurable. So if you're a seller and you have some minor damage that happens, think carefully about filing a claim with your insurance company. Title insurance, the buyer at the buyer's expense can purchase title insurance. Again, you are not supposed to be an expert on title insurance. If you have a buyer with questions on title insurance or is thinking about not getting title insurance, send them to your friends at Universal Title or whoever you're using to give them more information. The lender requires lender coverage. Lender coverage does not cover your client. So make sure that they understand that. Section 29 just gives us some information about definitions in the contract. So date of ratification is the date of acceptance by all parties, okay, to the term. So ratification happens when the final document, the final signature or initial is delivered back to the other side and acknowledge that they've received it, okay? That's the person who then puts the date on the contract, and that's the ratification date. The last person to sign does not put the date because that does not mean it's ratified. It is when it is accepted, received by the other side, okay? If you are negotiating and talking to the agent on the other side, and you've just got one initial left that needs to be done, in practice, it is okay to say, would you like me to put the date on for you before I send it back? They're going to say yes. You put the date on, you send it back, you make sure they received it. Everybody's good. Everybody's on the same page. But there have been many times that agents have put the ratification contract is not ratified because it's not actually initialed off on all the right places. So that's actually not the ratification date. So please be careful with that. Jackie's asking for property insurance. This used to say you needed to apply within 7 days. It still says that on the first page of the contract.
Shannon, quick question with regards to ratification date. If it's after 9 p.m., does it still, like, is there a 9 p.m. deadline? So if ratified at 11 p.m. that night, does it still count as that day, or does it technically count as the next day?
So 9 p.m. doesn't matter before you're ratified, right? 9 p.m. is only contingency deadlines. So there's nothing that's enforceable in the contract before you're ratified, right? And so the day of delivery is always day 0. And you can't invoke anything, right, until after you're ratified. So it could be 11:59 and it's still the ratification date. Appraisal means written appraised value conducted by a Virginia licensed appraiser, of course, right? A day is a calendar day unless otherwise specified in the contract. All of our references to time refer to Eastern time zone, and this says for the purpose of computing time periods, the first day will be the day following delivery and ends at 9 p.m., right? So the day of delivery, we say is day 0. Okay, so first day is the day following. The masculine and feminine and singular and plural are interchangeable. Legal expenses refers to a whole bunch of different things. Notices. Notices are unilateral communication from one party to another. This is only for things that are not negotiable. Okay. Notices are for things that don't require people to sign and agree. This is one side telling the other something. Buyer and purchaser terms are used interchangeably, and seller subsidy is a payment from the seller towards the buyer's costs at closing.
Hey,
Time,
Shannon,
yes.
could I ask a question on delivering notices? So I've never experienced this, but if someone decided, hey, we put an offer in, and that's not an actual contract yet, it's ratified, but it's an offer. And we've submitted it on, Sunday night at 9 p.m. and we haven't heard back Tuesday by 5 p.m. and we want to withdraw our offer. If we send an email saying we're withdrawing our offer before they send back a ratified offer, are we good to go with an email in that case, even if they haven't acknowledged it?
So the best way to withdraw an offer is to put an X or a red line through the first page, write withdrawn, have your client's initial, and then send it.
Okay.
So that your clients are withdrawing it and there's no question on who had the authority to withdraw the offer.
Now, I guess because normally, not always, but normally you have HOA, at least in this area, normally you have HOA docs or an inspection or some kind of contingency. If we had done that, but in the meantime, before we got it delivered to them, they sent over a ratified contract. Have you run into that where somebody was trying to withdraw while the other party, and like they were kind of crossing in the mail kind of thing?
Yeah, so they can't deliver a ratified contract. They sign off on it and then they deliver it back, and then acceptance is when so in your case, you would be the one putting the date on it, right? That it's ratified. They're not ratifying it, you're ratifying it.
Oh, the person with the final initials doesn't, if they just agreed to everything and just ratified and sent it back?
No, you weren't, you missed the couple minutes before, where the person who does the final initials is not the person who ratifies it. The person who receives back the completed offer is who puts the ratification date on it, because that person's double checking to make sure everything was done.
Got you.
In practice, it can happen where the person who is putting the final initials can put the date on, but there needs to be a conversation about it, because it needs to be not delivered back at 11:59 at night, where everyone on one side thinks that today is the ratification date, right? So you lose a day, but it's really not seen until tomorrow. So you don't have a meeting of the minds.
Okay, thank you.
Gailey.
So just to kind of follow that thinking out, I'm just wondering, so what if that conversation didn't happen, right? And it's going back and forth, and the last agent gets all the initials and puts ratified in there and sends it back to you. And in Jeff's situation, they want to withdraw. How do you prove that it's not ratified? Like if you didn't give them permission to put that in there, but they did it anyway and sent it back and said, okay, here we go, we're ratified. And you want to say, wait a minute.
Somebody putting a date on a document doesn't make it ratified.
Okay, so.
Acceptance of the completed document makes it ratified. So in a case where you are communicating with the other side, they put the date on for you and send it back, you still have to acknowledge that you received it, so that everybody's on the same page, that yes, in fact, it is received and ratified.
Okay. So if they
Now-
did that, if they put the date in there, there was no communication, but they spent it ratified, and you got that and they sent that back to you, at that point, you would send a notice saying, we don't accept this?
Well, in his situation, they would have already sent the withdraw. He's saying it crossed, right? They sent the withdraw at the same time, like it crossed in the email,
Okay.
right?
Okay.
Well, it would, right, in your example about the date, it would just be like they send the contract back and you put the date in, but you put the wrong date. That doesn't make the wrong date the ratification date, right?
Mhm.
You put a typo. That doesn't make that the ratification date.
Oh, Shannon, the contract is ratified. Not only your client signed and put ratification date, the other side has to receive it. We have to have confirmation, right? Receive it.
Mhm.
So if I
Yeah.
get it, if I send it tonight at 11 o'clock and they haven't seen it until tomorrow midday, let's say, in between that, can I withdraw if my client no longer want to pursue that property? If I haven't received that receipt?
Well, maybe not. I would say no if you've sent it back. I mean, it's possible. It depends on the scenario, right? I mean, if they really haven't seen it, then yes, you could, I guess, withdraw it. But once you send it, then if you intend it to be ratified, you have to be very careful on that.
Okay, thank you.
Shannon, when you say that they've acknowledged that they've received it, can it be a verbal acknowledgement, like, yes, we just got it back, or does it have to be something in writing?
I would do it in writing because you're not the one that's putting the date on it. So it would need to be, I would do it in writing. And this is what I do all the time. If I in practice, right, I send an offer out and it gets signed off and an agent will send back to me and say, attached is the ratified contract, right? But they were the last ones to initial. They send back to me, attached is the ratified contract. I will reply and say, yay, we're officially ratified, right? Or, received, we're officially ratified now, right? I'm acknowledging that I've received it. And at that moment, we're officially ratified because I've acknowledged it, right? It's not, a verbal is not.
Okay, so as long as, if they've signed it and they've put in the ratified date and send it back, you still say, okay, we're ratified. You do it, you do it.
Oh
Okay.
yeah, absolutely. Absolutely. All right, time is of the essence just means that dates and timeframes agreed to must be met. Parties acknowledge that so-and-so in the contract or is related to somebody in the contract is active or inactive in Virginia or another jurisdiction, right? So if you are a party to the contract or are related to a party in the contract, it has to be disclosed. Entire agreement, the contract is binding upon the parties signing, and their heirs, executors, administrative successors, and permitted assigns also can bind the contract. The contract may not be assigned without written consent of buyer and seller. Assignments are very tricky. So I would say if you have somebody who wants to consider an assignment of the contract, let's talk about it first. The original parties to the contract remained obligated until settlement. That is a huge thing in assignments. So let's try to avoid those. The next section talks about the additions to the contract. So when I'm reviewing offers and contracts that come in, I'm looking at this section to see what is attached, what's supposed to be attached. So this is where you're indicating to the listing agent what addendums are part of this ratified contract. So are you adding a home inspection contingency, lead-based paint contingency, contingencies and clauses addendum, et cetera, et cetera? Is there an escalation addendum? In other, this is where you would put, if you have designated agency, right? We went over designated agency on Monday. So 2 agents that are under my broker supervision, doesn't matter which office, is designated agency. That is part of the offer. Same as unrepresented disclosure. That is part of the offer. Okay. Brokerage information goes here. Fill it out completely. Even if the agent on the other side doesn't give you the information, you all have access to find all of this information for everybody. You have access to find firm license numbers, their agent license numbers, their Bright MLS broker codes, their Bright MLS agent IDs. You have access to all of it. Okay, DPOR and Bright give you access to all of it. Now, I am going to give you the brokerage license numbers for your respective market centers. Falls Church, 0226 025 117. Okay, Falls Church was 0226 025 117. Kingstown 0226 030 118. So again, Kingstown is 0226 030 118. And Fredericksburg is 0226 008 747. Okay, 0226 008 747. And you can always find that up, look that up by going to your own license in DPOR and clicking related licenses, and it'll come up. All right, let's knock out some financing addendums. We can get these through these really quickly. There's 4 of them, and we're not going to go through all 4 of them. We're going to go through the basics, and then I will tell you what's different about the other 3. So conventional financing. This is the document that you include if your client wants conventional financing contingency. It includes the appraisal contingency as a separate contingency from financing, but they're on the same addendum. This is important for filling out the information on page 1 where it says specified financing. It means the terms set forth in paragraphs 2A and B of the main contract. So remember when I said you have to fill it out correctly on page 1 and to use percentages instead of dollar amounts, because if you don't update things and it's not going to match on your specified financing, this is why. Noshin, your question is what is the license number for? Well, it's for this right here. It requires the license numbers on your contract. So here you're going to fill in information about the first trust and the second trust. Are they obtaining or assuming the loan? Right now, almost everything is obtain. Every once in a while, you'll see an assumption, but right now the rates are really good on the just taking out a new loan. You'll see assumptions when the rates on new loans are higher than loans that are assumable. And is it fixed or adjustable? And how many years is it amortized over? And what's the interest rate? Okay, this is information you get from the lender letter, right? That pre-approval letter that you have before you go and show homes. Section 2 explaining.
Shannon?
Yes, Jeff.
Back on the interest rate, I've seen people put market in there, and I've had listing agents say they want that. Any opinion on putting market when it has a % sign?
Well, is market percent a thing?
No,
Okay.
that's what I said.
So by putting market there, what that means is that any current interest rate is what they would be obligated to. But what if they're not qualified? What if the rates jump to 7%? What if they're not qualified for a loan at 7%? It needs to be an interest rate that they're qualified for relative to what the rates are right now.
So if they ask to put market, do we tell them no?
Well, you explain to your buyer what this means, and then your buyer gets to decide whether they're putting something. Remember, this isn't you that makes all the decisions, right? You're explaining to your buyer, right? And market percent is not a thing.
Okay.
Right? There's a reason that it says blank percent, it's not a text box.
In the event that, let's say you put a rate and then since they are kind of climbing up right now, it went above that, is this an opportunity then for you to be able to void if necessary?
So what you're going to do is you're going to talk to the lender about what the range is that they're qualified for. So if today the rate is 3% and they're fluctuating and they're qualified, 3.5, whatever, then I would put 3.5. Or if they're comfortable and qualified going up to 4, no matter what is, where it's happening, then I would put 4.
Okay, and then if it goes above that, that's where you have the opportunity to walk away.
Well, they have to get declined for the finance. Okay, alternative financing. It says the financing contingency will not apply to any alternative financing. Okay, what this means is that if your buyer does not apply for financing and get declined for financing for the terms that are in this contract, then the contingency does not apply. So what happens when the buyer says to the seller, I'm going to get a conventional loan and I'm going to put 20% down, and then they switch to an FHA loan with 5% down. They have no contingency. They also have no contingency if they say to the seller, I'm going to get a conventional loan with 20% down, and then they switch and they apply for a conventional loan with 10% down and they get declined. That decline letter has to match the specified financing in this contract. So when you have page 1 and you're going back and forth and you're negotiating and you forget to change what your financing terms are and you get declined for something that is not what matches, that's when we get in trouble. And so that's why I like percentages.
So Shannon, sorry, you recommend to, in case the financial will change, you recommend to do an addendum? Let's say something happened that, the financial is going to change. What do you recommend to do after ratification? To do an addendum and explain that the financial are changed?
So if there's something, so if the seller is agreeable to it, then the buyer wants to maintain their contingency, there's 2 different things that would happen. If they're changing from conventional financing to FHA financing, for example, simply having the FHA financing contingency addendum signed does not satisfy the specified financing change. You also need an addendum stating that the specified financing has been changed to FHA and whatever the loan amount and down payment are. So you need 2 things. If it's within the same type of loan, so if it's still conventional and you're going from 20% down to 10% down, and you want to maintain that contingency, then it simply would be an addendum that says that the specified financing has changed and what the new financing is.
Perfect. Thank you.
The seller does not have to give permission to a buyer to change to alternative financing. What will trip people up is that FHA and VA appraisals require a document to be signed by the seller. So it's not giving a financing contingency, it's actually giving an appraisal contingency. And we'll talk about that in a minute. So all of our financing contingencies have two choices. They have automatic extension and automatic expiration. And what this means is that at the end of the automatic expiration period, the contingency is done. So if the buyer gets declined after the expiration date, it's too bad, they're in default, okay? There's nothing else that happens. In automatic extension, if you put in 21 days, it automatically extends up until the date of settlement unless the buyer delivers a copy of the conditional commitment letter, which is not a clear to close, right? It's a commitment letter that removes the contingency. So that could be something that lists a bunch of conditions on it, and the buyer can still get declined because the conditions can't be met. Or at the end of that 21 days or however many number of days you put in, the seller can serve notice to the buyer and say, hey buyer, you've had your 21 days. I'm going to give you 3 days to decide if you're going to move forward with this contract, or you can void. And you can void for any reason. You don't have to get declined. There's no information that the buyer has to provide from the lender. They just void. So that's 3 days from the seller delivering the notice. Now that's a risk for the seller to deliver the notice because the buyer can just void and the seller has to start over. The seller doesn't get their earnest money. There's nothing that happens, okay? In most cases, it's a game of chicken, right? Buyers don't want to remove their contingency and the sellers want the contingency removed. This is a game of chicken related to the earnest money deposit. It's not about them getting to the closing table. It's about the earnest money deposit. So if the seller wants to deliver the notice to remove the contingency, then my suggestion is only do it in a case where you are pretty sure the buyer's not going to get to closing. Like there's something really suspicious or really wrong and the buyer's not going to get to closing. And so you're trying to give them the out and get them out of your hair so that you can go back on the market and sell to somebody else. All right. Anna.
Shannon, I'm so sorry. So what you
Okay,
recommend?
wait. Veronica, wait. Anna has a question first. She had her hand up, and then I will come to you, and then I think Z unmuted also. All right, Anna.
If the conditional financing letter is sent by the lender to the seller rather than directly from the buyer, as the lender is not party to the contract, does that still count as financing contingency?
What do you think?
I think it's a yes.
So I'm going to think it's a no on that one because the lender is not listed anywhere here as a representative of the client. So the agent is the one that's listed as the representative. So I'm going to say no. I would argue no, that it's not. Veronica.
So you recommend us to put a financing contingency with automatic expiration only in case we have a client that, we know that it's difficult to, to be able to arrive to the closing table. Do I understand correct or not?
No, for a buyer always wants automatic extension and a seller always wants automatic expiration. And quite frankly, both are irrelevant to whether the buyer is going to get to the closing table.
Right. So to make a strong offer, we should not put an automatic expiration, right?
Again, they're both irrelevant, right? Because either you're getting to closing or you're not. Whether it's all about the earnest money deposit.
Okay.
It's all about who gets the deposit. So, I mean, if I'm wanting to protect my buyer, then it's automatic extension. because I want that contingency up until the date of closing. And quite frankly, I want it to get to closing. So I really don't care when the contingency expires. I just want to make sure they get to closing.
Okay.
Okay, Z, you're next.
Is 21 days the norm?
It depends on how long your closing is. So if you have a 45-day close, then 21 days is not enough because you can't get far enough into your financing to really feel good about whether or not they're going to get that clear to close if I'm a buyer side, right? If it's a 45-day close, I want 35 days with automatic extension, right? That's what makes me feel good. If it's a 30-day close, I want 28 days with automatic extension and a 21-day appraisal contingency. It all depends on when your closing is.
Okay, thanks.
Yeah. So with the appraisal contingency, which is the next section, conventional financing is the only one that has it separated. This you can say that your financing contingency is in place, but the appraisal contingency is not. You can say it's not contingent on the appraisal, but still have to have an appraisal for the function of the loan, right? That's what we were indicating on page 1 of the contract. So the contract is or is not contingent on the appraisal, and we have until 9 p.m., however many number of days from ratification to get that appraisal done. So then it goes on to say what happens based on the results or not of the appraisal. All right, so if the appraisal could be equal or greater than the sale price and the contingency is satisfied or removed, the buyer can elect to proceed with the contract without regard to the appraisal, and they can remove the contingency. The appraisal can be equal or greater to the sale price, but the buyer is not going to proceed because there's some issue that the lender has requirements that cannot be satisfied, right, with the condition of the home. The appraisal is less than the sale price, and the buyer does not want to move forward unless the seller reduces the price to a certain amount of money. Okay, so those are the choices. In conventional financing, the buyer cannot void without negotiating. The buyer has to negotiate before they can void. Teo, you have a question?
For option B, where you're saying they can proceed, is that the case where the buyer would bring the cash difference between sales price and the appraisal amount?
Yes, they would have to. And that's the case where like the appraisal hasn't been done yet and they can't wait any longer for the answer. And so they just remove the contingency.
Okay.
The appraisal is less than the sale price. Okay, so, and the buyer elects to proceed with consummation of the contract if the seller elects to lower the sale price. That doesn't have to be to the appraised value. I also want to point out, it can be to any price in between, right? So that's where like the pre-negotiated, buyer agrees to pay $10,000 above lender's appraised value comes in. So it could have been $20,000 low and they already said they'd pay 10. So then that's the price you put in. So now the negotiation period, in the event that you have an issue and you have to negotiate, you have blank number of days to negotiate from the time that the notice is delivered. Okay, the notice being delivered saying what's happening is day 0. And then there's a buyer election period. So if you all don't come to an agreement, then you have a buyer election period that says, okay, the buyer takes it at the contract price or they void. If the buyer has not delivered the appraisal contingency notice by the deadline, right? So if you put 21 days in and the appraisal contingency notice hasn't been delivered, then the seller can deliver a notice to the buyer that the buyer has 3 days to void, just like the financing, okay? If they don't void, then the contingency is just automatically removed. Lender required repairs. The lender required repairs is the same on all three or all four contingencies. If there's lender required repairs, buyer serves notice to the seller, and then the seller, within 5 days, has to tell the buyer whether they will make the repairs. And if they will or will not make the repairs, they still have to give notice back to the buyer. And then the buyer can decide whether they will give notice back saying that they will do it, right? If nobody's going to do the repairs, then they void the contract. So the seller is not required to make the repairs. They are required to give access to the buyer to make the repairs to comply with the contract. And if nobody wants to do the repairs, then the contract is void. Yes, C.
Yes, thank you. So the negotiation period and the election period, I've had different agents giving me different number of days. What would be the norm for both?
I think that up front, you know what your client's comfort level is on how much they're going to be willing to pay. I also think that you will have done your homework before making an offer, so you know whether the appraisals should be an issue or not. So you shouldn't need more than a couple of days in each, right? Maybe 3 days and 2 days. Like, you shouldn't need much time because you should have an idea up front on what is happening.
Right, that's what I usually do, 3-2. But for one of my deals, the agent only wanted 24 hours for negotiation. So is that acceptable?
It's whatever the buyer and seller agree to.
Okay. Thank you.
Sure, Jeff?
Hey, Shannon, thanks. I had two questions. One, going back to the appraisal. So there's a, should we be doing, because it says it has not delivered appraisal contingency notice. Like, typically we would just I would email the seller and just say, hey, the appraisal came in at value, and then we just move on. Is there a form we should be sending with that? Or only if we're?
There is, and we will be getting to that shortly.
Okay, great. And then second question. So I've always been curious how, if we needed repairs, and I'll just give you an example because this came up. VA loan, VA says, hey, you know, the roof needs to be replaced. The buyer says, you know, I don't mind paying for that. The seller doesn't have the proceeds till closing. To move forward, we have to have it replaced, I would assume, before closing. So the buyer pays for a roof, but then something blows up and you never go to closing. How does that work out?
Well, that's a risk. And there could be an agreement written by attorneys on the seller repaying the buyer for this roof. That's done. There's also ways for, I mean, some vendors will take a deposit and then payment at closing. You know, so it's not a buyer paying out of pocket for some certain things. There's also certain types of repairs that FHA and VA will allow to be done with an escrow at closing and then be cleared afterwards. So just make sure that you're always talking to your lender. All right. So moving on to FHA. So I'm just going to point out the couple of things that are different on FHA finance. on FHA financing, there is a section that's called FHA required notice. This is a document that many of you have seen. Many of you, I'm sure, have seen it in offers where it doesn't belong. It is initials from the buyer saying that they have acknowledged receipt of the HUD form 92564 for your protection, get a home inspection. This is on the HUD website, so you can just go, it's not in the forms library, but you can just go on and bookmark it on your computer. And anytime you have an FHA buyer, you can just email them the link so that they're not lying and that they actually did get a copy of this notice. It's just a notice reminding them to get an inspection. These contingencies are the same. Automatic extension, automatic expiration. What you will see here, though, that's different is appraisal provisions. There is not a section to say it is or is not contingent on the appraisal. So what this means is that the appraisal is part of the financing and it cannot be separated. The FHA amendatory clause is something that has to be acknowledged by the seller, and it's the escape clause from a contract if the property does not appraise. And this applies regardless of whether there is a financing contingency. Okay, it is the law. It doesn't matter whether they agree or not. The buyer can still get out, but to get to closing, the seller has to sign the document. Okay. So in this blank right here, this is where generally you put the sale price that's on page 1. Now, you don't have to put the sale price that's on page 1. If you're agreeing to a difference, like that the buyer is going to pay a difference, then this number would be different. So this is stating that the appraised value would not be less than blank. Then the buyer shall have the privilege to proceed without regard to the appraised value, but they also can void if it's less. All right, so you could put a different amount here. Here are the appraisal procedures. They're exactly the same as we just went over in the conventional, except that the buyer can elect to void the contract. If the appraisal is less than the sale price, they can just void. That's an extra one. So in FHA, USDA, and VA financing, there is absolutely no requirement for the purchaser to negotiate. Conventional financing requires the purchaser to negotiate. Section 7 clarifies that in the wood destroying insect inspection, fences and outbuildings must be included in the inspection and certification. Okay, all of the lender required repairs section is the same. And then the buyer, seller, and broker, agent, I'm not signing this. I have no idea whether what is filled out is correct or not. So this is agent that signs. The buyer, seller, and agent certify that the terms of the contract to which this addendum is attached are true and correct to the best of your knowledge. Okay, agents must sign this. Okay, VA financing, the same, right? We add the assumption section, which is on the VA as well, or on the FHA as well. Automatic extension and expiration are the same. Appraisal provisions, here's where, again, it doesn't pull out the appraisal being separate from the financing. The FHA amendatory clause counterpart in VA is called the VA notice of value. So this is what the seller has to sign. So you don't have to have a financing contingency with VA. Your client can waive it, which again, I hate financing contingencies being waived. But you can reach out to your lender and say, hey, can you send me the FHA mandatory clause for the seller to sign because we're waiving the contingency? Or can I have the notice of value document for the seller to sign so that they're acknowledging the document when it comes to the appraisal procedures, but the whole contingency is not there. And in VA, number 4 is the same as an FHA, where they can just walk away. The wood destroying insect inspection section clarifies that fences and outbuildings must be included and that the seller has to pay for the inspection. All right, this extra little section on deposit is just a clarification on how deposits are handled, which is not any different from normal. Okay, and then there's USDA. Again, another version of what we have just been looking at. USDA has a mandatory clause that is very similar to FHA's mandatory clause. Appraisal procedures are exactly the same as FHA and VA. Fences and outbuildings, just like FHA. And the agent must sign the document, just like FHA. Okay, so what happens if you have a buyer who is waiving their financing contingency and they want to have an appraisal, right? What do? Well, you use this document in DocuSign. I believe it's called appraisal contingency cash purchase or something. It's a little misleading, but it's the appraisal contingency, no financing contingency. So this lays out what happens for the appraisal contingency if it's either a cash purchase or the financing contingency is waived. This actually gives you your predetermined negotiation and buyer election periods. Okay, it's just, it pulls from the other documents. So you don't have to worry about rewriting anything.
I'm sorry, Shannon, can you repeat? I didn't understand this one. I apologize.
This is just the appraisal contingency document, so that if there's no financing, then you just have the appraisal contingency without the financing addendums.
Shannon, actually, this one is used for cash offer if buyer need to for appraisal this property. So the cash offer have no any financial. That's why we use this one for buyer protection. Yeah.
Yeah, it's for cash or anytime there's no financing. So if even if the buyer is getting a loan, if there's no financing contingency or they're paying cash.
Okay, thank you.
Okay. And actually what I'm going to do is I'm going to skip ahead a couple pages. And we're going to scroll down with me, if you will, to, oh, is it not in here? Oh my goodness, we're missing. Oh no, these are offer documents. Never mind. Okay, do you guys have your post ratification package handy? Does everybody have that handy?
I don't think that was in there.
I'm trying to decide if I want to, never mind. We're not going to do that. Never mind. I'm going to confuse you guys. All right. So we're still
you are talking about the appraisal contingent notice?
Nope. Yeah, but we're not going to do that. We're just going to keep going in this package. Okay. So the other contingency that's very common is the home inspection and radon contingency addendum. This document changed. Okay. This document has a new paragraph 1. And what this did was it took a paragraph that was in all of the different options and just made it all encompassing. Okay. And this talks about the utilities and things like that. So what it says is that if the utilities are not in service for any of the inspections that are listed here in the addendum, that there's a certain number of days that the deadline is extended. Okay. So if the seller didn't have the utilities on like they're supposed to, you get to extend your home inspection contingency or your radon contingency or whatever the case may be. Okay.
How many days you put?
I put 5 usually, but it depends on how busy your inspector is. I mean, sometimes you might need 7. It just depends. If the buyer fails to obtain their inspection reports or radon report, or fails to deliver the copy of the report to the seller, or the notice to void with the copy of the report, or their wish list, the contingency expires, and then they have no more contingency and the contract remains in full force and effect. Okay, so that is something that is listed in the top just as a general provision for everything. So we have 2 choices with home inspections. You have the home inspection with right to negotiate repairs or void the contract. So what this says in 2A is that the buyer has blank number of days to conduct their home inspection or inspections with a licensed professional insured inspector at their own expense. It clarifies in here that the home inspection contingency does not include radon testing, well inspections, or septic inspections. Okay, so a buyer can't say I'm waiving my radon test and then go put a radon test in during the home inspection and try to void because the radon was high. Okay, that's not okay. If they put a radon test in the house, they have just breached a term in this contract. They have to have a separate contingency for that. However, they can have a pool inspection, a chimney inspection, a roof inspection, a mold inspection, whatever other inspection they want in the number of days in that first blank in 2A. Sometimes you know ahead of time all of these inspectors that you want to bring in, and sometimes you don't. Sometimes you don't know until after you have that initial inspection that you need subsequent inspectors to come in that are specialized. So once you have done your inspections, your buyer has 2 choices. Your buyer can deliver a full copy of the report or reports with the inspection contingency removal addendum listing their wish list, or they can deliver an entire copy of the reports with the notice to void. Okay, the reports always have to be included. Now, if they're delivering the notice to void with the reports, please make sure you include the release of sales contract and earnest money deposit so that your client gets their deposit back.
Question, Shannon?
Yes, Jeff.
So the notice to void, it just says a copy of the agreement, but it doesn't say there has to be anything wrong. I know normally the home inspector is going to find something, but if there was nothing wrong with the house, can they still void?
What do you think?
I mean, it says send a notice along with your notice to void. It doesn't say there has to be anything wrong.
That's right. There doesn't have to be anything wrong. So if there is a wish list, yes, Anna.
One other question. So you're sending your wish list or notice to void. Does that mean you can't request a financial money off the bat from the seller instead of your wish list, or can you include like give me 300, or $3,000 in lieu of any repairs.
That is your wish list, is the money.
Okay, so you can ask for money off the bat.
Sure.
Thank you.
And it's actually what I recommend if you have a picky buyer. I don't think that sellers and buyers have different opinions on what constitutes completing items. And so I always suggest asking for money if there's money available. If you haven't already negotiated all of the seller subsidy covering the closing costs. So in the negotiation period, if you are delivering a wish list, this is when you are reviewing and going back and forth to see if buyer and seller can come to an agreement. So the day that the copy of the wish list and the full report are delivered is day 0. Okay, it's not the day after the inspection period expires, right? So if you have 10 days in 2A, day 11 is not when the negotiation period kicks in. If you deliver your wish list and reports on day 5, then day 5 of the inspection period becomes day 0 of the negotiation period. Now, depending on the condition of the home, will depend on what I put in the negotiation period. I suggest no less than 3 and no more than 7. 5 tends to be a good number based on our market right now, but it depends on the condition of the home and how it's presented and how picky your buyers are. And then buyer election period is what kicks in if you were not able to come to an agreement in the negotiation period on what repairs or credits will be given. At 9 p.m. on the last day of the negotiation period, buyer election period kicks in and says, okay, buyer, you have blank number of days to decide if you're going to take it or leave it, an as-is condition. And here I would put 2 or 3. Now, section 3 is home inspection with option to void only. So this is pretty easy.
Shannon, how many days you put on the inspection period on the top?
So that depends. That depends on the condition of the property and your inspector's availability. I'm usually checking with my inspector before I make an offer to see when he's available. If the condition of the property warrants that I know I'm going to need a roof inspector or a pool inspector or something like that, then I'm going to be checking availability before I put the offer in. A strong offer is a quick inspection, but it all depends on the availability.
Yeah, because I also see 3 days. So do you think 3 days is, I think 3 days is good, or I look like, it depends, right? Of course, but 3 days.
Yeah, it depends. I mean, if I called my inspector and he had a cancellation and he's available, tomorrow, and I might be able to get ratified today, or he has a couple of openings over the next couple of days, and 3 days is strong, right? It depends on the situation. Inspection with option to void only is easy. You have blank number of days to do your inspection and decide if you're taking it or leaving it. If you're leaving it, you deliver the report with the notice to void. If you're taking it, you just let it expire. No harm, no foul. Radon testing is very similar to the inspection with right to negotiate or void. There's just a couple of extra things in here about EPA testing guidelines, which you can read on your own. If the report comes back and says that the result is above 4.0, then the report and the addendum requesting remediation and retest go to the seller. The buyer can simply void if they are uncomfortable. If the report comes in and says that the radon is below 4.0, they don't get to void. This says that if the radon report confirms the presence of radon that equals or exceeds the action level established by the EPA, which is 4.0, then they have these options. If it doesn't, then they can't use that as an excuse to void. Okay. Here's the negotiation period and election period, just like before. All right, let's get through this, and then I will give you another quick break. Private well and septic inspection contingency addendum. This is for well and septic, of course. There's a water potability test that can be done at seller or buyer's expense to test the water potability, which is checking to make sure it's the well water is free from contamination of chloroform. And a lot of times the seller can just take this sample to the county and they can test it there for them. And this contingency requires that the report be dated within 90 days prior to settlement, just like our termite inspection. The well and well water test, or well and well water inspection contingency is here. What it talks about here is that the well inspection is done by the buyer at the buyer's discretion, expense, and sole risk of damage to the well, and that they should retain a professional and insured inspector to inspect the well and the well water. Okay. When you're doing well and septic inspections, because of just the nature of a well, right, and septic system, there can be damage. And so this is putting the buyer on notice that there can be damage. And so to be careful on who you're hiring. It is a notice to void situation with a copy of the report, or wish list with remedies and a copy of the report, just like on the home inspection with right to negotiate or void. Okay, we have the negotiation period and buyer election period. Very easy. Septic is a little different. Okay, septic, there is an alternative system disclosure here. So do you have a maintenance contract, seller, if you have an alternative system, and does it convey? And then for the inspection itself, because septic systems actually have a risk of even more damage that can happen, this is something that you can ask the seller to do at the seller's expense and sole risk of damage. So the buyer can say they want the seller to do it, and that they want the seller to do it and hire whatever company, right? So there's a blank for the company to be put in here. I will tell you that septic inspections take a lot longer to schedule than regular home inspectors. And so this is a lot of times 24, 25 days in this inspection contingency. The second part down here of the paragraph says that if there are impediments that are not removed and the inspectors can't get to the system where they need to inspect, that there's an additional days that it automatically extends. Section 2 talks about what happens if the seller is who is providing the inspection report. And what it says is that the seller has to provide the report within a certain number of days prior to the inspection deadline so that it can be reviewed. Because the buyer has to have time to review it before the deadline, because they have to send their wish list or notice to void, right? So that you can't have a seller that delivers the report on day 23 when it's a 24-day contingency. So here, I generally say that it needs to be 3 or 4 days prior to the contingency deadline that the seller has to deliver the report to the buyer so that the buyer can review it. Now, if the buyer has never lived on well and septic, you might want to say 5 days. You might want to give them a little more time so that they can review, okay? The next section talks about how the septic inspection automatically has to include a walkover visual and a probing of the drain field. And then the buyer can ask for a pumping and inspection of the tanks. And if they want an excavation of the distribution boxes to test all the pumps and controls and evaluate the function. Now, depending on the age of the system, excavating that box might destroy the box. So you might have to think about that. All right, there are some hands raised. So let me go and see. I think Pam, you may have had a hand raised.
Yeah, I had a question. If you require the seller, could you, as you make your offer stronger, credit that seller at closing?
Yes, I do see that all the time.
Okay, all right.
Yep, we do see that regularly. Absolutely. So they're taking the risk and the buyer is crediting for the cost of the inspection. Absolutely. Z, you're next.
Yes, so since it takes between 24 to a longer, and you say to put like 24 to 25 days, you wouldn't recommend a 30-day closing, right? If this, okay.
That's correct. That is correct. Okay, I'm gonna give you guys a break now. So let's just take a quick break and be back at 3:10, and we will knock through the contingencies and clauses. All right, friends, it is 3:10. So we are going to talk about the contingencies and clauses addendum. Once I see a few more of your faces come back on my screen. There we go. I have a few of you there. All right, so our contingencies and clauses addendum is a document that is a bit of a catch-all for like some miscellaneous clauses that we have that we don't have on their own addenda. So they are put on this 4-page addendum. And this is one of those that I was talking about on Monday in DocuSign, that when you add it to your DocuSign room and you use your pre-tagged roles, it's going to put your initial blocks here on everything, so that, and they're all optional. So you have to go in and delete everything that doesn't apply and then make required what does apply. So you're only having your client's initial next to the paragraphs that you actually want to invoke from the contract. So the first couple of sections on this talk about when a buyer has a home they're selling and they want either the sale of their home or the settlement of their home to be a contingency in the offer. So this first section is for when the buyer's home is not on the market yet. Okay, so what it's saying is they want the seller to give them time to get the home on the market, get it under contract, get all of the contingencies removed, and then get it sold so that they can have the proceeds for the purchase. Okay. When you have the home already under contract and already with all the contingencies removed, you use the contract, right? The sale of the buyer's property at whatever their other address is what the contingency is talking about. So depends on what market you're in. But what you need to remember in this time frame is that the blank number of days has to be enough time to get the home under contract, right? So it's got to go on the market, get under contract, and get through the buyer's contingency. So you don't put 5 days here, right? You put like 30 days or something. You have to know what the market is. If it's a unique property and it's going to take 6 months, then you have to put 6 months. You can't put 10 days. You have to really think about how long is it going to take to do all of those things, right? In this market, this contingency is not very likely to be accepted because they're going to get offers that aren't contingent on the home sale. So think about whether or not your client should be doing this, right? Maybe they should put their home on the market first and do a home of choice contingency, but we'll get to that in a minute. So here's your contingency. Now what it says is if the buyer doesn't satisfy the contingency, or you don't come to an agreement to amend the contingency, so like extend the contingency or remove the contingency by the deadline, the contract just becomes void. So if you put 35 days here and the buyer hasn't satisfied their contingency, you haven't agreed to extend it, and it hasn't been removed, then the contract is just dead. It's just done. Now, where does the kick out come in? Well, the kick out comes in because in Bright, this home is going to be marketed as active under contract, and the seller is going to be looking for backup offers. They're going to be looking for someone who can move forward without a home sale contingency. So the seller may continue to offer this property for sale and accept backup offers to this contract until it's satisfied or removed. If a backup offer is accepted, okay, so the backup offer has to be ratified as a backup offer. The seller will deliver notice to the buyer requiring that the buyer either remove or satisfy the contingency subject to the terms below. And they have a certain number of days to do this, okay? So what does that mean? It means that the buyer here in this case has to figure out how they can move forward with this purchase without the sale of the home. So they have to get a lender letter saying that they have the funds and they can do maybe some different type of loan, whatever. And they have to prove it, or they have to magically like get a cash offer on the home they're selling and provide proof that they have a ratified contract on the home they're selling with no contingencies. And there has to be a certain number of days given to the buyer to satisfy this kick out before they are kicked out and backup offer gets moved to first position. Okay, so that's where the term kick out comes from, is that even though there's a number of days up here in this that says that the seller is going to give the buyer a certain number of days, they don't have to wait those days before they accept a backup offer. They're going to allow the buyer to be ratified and work through their stuff, but they can still kick them out if somebody better comes along. All right, so here I say it's usually like 3 days, maybe, for the kick out. Sometimes 5. I've seen as many as 7. 1 is unreasonable.
Question, Shannon.
8, yes.
So on this sale of buyer's property and kick out, when that date is just the ratification date, it's not, that doesn't have anything to do with closing on the home they're selling. That's the next paragraph, right? So the kick out only refers to getting a ratified contract on your home for sale. Is that right or not?
It's not closing. It's ratified with evidence that all contingencies have been removed.
Oh, including removal of all contingencies. So that could take, I mean, if it sold a week after you put the offer in on the other house, it could still take 3 weeks to remove all the, I mean, you could still be looking at, that's assuming you sold it right away, right?
Right. So that's why my suggestion up in this first one is that it's not a quick number of days, because you have to get an offer and they have to get through their contingencies in order to be able to remove your home sale contingency.
Gotcha.
So like here, when you're served notice, the only choices you really have are getting a cash offer with no contingencies, or your lender finding a way that you can buy without selling your other home. Those are basically your 2 options. So A2 says that the buyer's property will be listed exclusively and actively marketed with a licensed real estate broker entered into the MLS within a certain number of days after ratification of this contract at a price not to exceed blank. Well, why is this there? Well, that's there because the seller of the home that your buyer is offering on wants to make sure that you're listing it for a reasonable price and that everything possible is going to be done to try to sell it. Okay. Now, here is where it explains how the buyer can remove the contingency. They can't just chance it and remove the contingency and say, I think we're okay. They can either satisfy the contingency by delivering a copy of that full ratified contract showing that all the contingencies are removed or waived, right? Or they can deliver a letter from the lender saying that they can do it without the sale, or show that they have cash. Those are the choices. Now, settlement of that home is separate from the rest. Okay, so even if they deliver evidence that all of the contingencies have been removed and everything's good, the contract still is contingent on that other home settling. So if something happens and the contract falls out and that settlement never occurs, this paragraph still survives. Hey guys, I know this is unconventional for me to do this. I reached out on our break to the chief counsel at NVAR to clarify something, and he's calling me back. So we're going to take 30 seconds for me to clarify something. So hold tight. Okay, guys, I'm sorry about that. There was a change to the title paragraph of our contract that I did not highlight for you guys when we were reviewing it, that I wanted clarification on. I kind of had an aha moment about it, and I didn't want to say anything, but I got the clarification on it. And I don't know if our friends at Universal Title, I don't know if Shannon is actually on with us at the moment, because I know that this is something that we've been talking about. So I don't want to I don't want to review it if she's not actually able to be with us at the moment. So I'm going to wait. I'm going to keep you guys in suspense, but it's really, it doesn't affect how we do things, which is good. It's just something that caused us a little bit of heartburn in explaining it. So anyway, I really appreciate you guys allowing me to take that call, because I would never take a call while we're teaching a class, except that was information that I wanted to give you for the class. Perfect. Yes, thank you. Let me know when she gets back, because she's going to want to know the answer to this, and then we will talk about it. All right, let me share my screen back with our document here. And where did it go? Here we go. Offer docs. All right, awesome. So we were talking about how the settlement of the property sort of survives when you remove the rest of that home sale contingency piece, which is great, because even though they've satisfied their contingency, something can happen and they don't get to the closing table, right? Anything's possible. So you don't have to worry about that. There is a blank here in this paragraph that says settlement may be delayed no more than blank number of days after the settlement date specified in the contract without parties' written consent. I don't like having anything in here more than 1 day, because the parties are counting on settlement, right? Because that's the date that everybody is counting on. Now, if you have a seller who the property's vacant, they're not counting on the funds to fulfill another transaction somewhere, it's not going to hurt them any if it says 3 days or 5 days or whatever. But from a practical standpoint, a lot of the time, clients are counting on the funds from the settlement to fulfill some other obligation. So be careful with the number of days that's in here. If you're on the listing side, look at this. If you're on the buy side, think about it before you just throw a number in here on how it actually affects a transaction. Okay. Now, seller will or will not accept assignment of funds. What this means is that the funds from the sale of the home that they are getting rid of have not dispersed to the new title company who's handling the sale of the home in this contract that we're working on. So I err on they will accept the assignment of funds, because then you can do closings in a closer time frame. So you don't have to wait for it to fund and disperse and then have the money go to the next title company. Okay. So talk to your clients about that. Settlement of buyer's property by itself is used when the property is already under contract, contingencies are removed, everything's good, and all you're waiting on is the settlement, right? So it's the same paragraph up here, but by itself, when you didn't need to have the home sale contingency time period put on there. Okay. All right, perfect. Shannon, you're back on here. I'm going to knock this out, and then I'm going to talk about the title paragraph, because I got some clarification for us. Contingent on the seller purchasing another home. This is an awesome underutilized contingency that we have in our contract, especially when there is tight inventory. This is the home of choice contingency. What this says is that the seller, right? It's the opposite of the buyer's home sale. This is the seller's contingency to go and find another place to live and get through their due diligence. So the seller is saying, hey, buyer, I love your offer, I'm gonna ratify it, but I don't have anywhere to go. So I need you to give me a certain period of time to go find another house and get through my contingency, my due diligence. And if I can't find a place in this period of time, then I can void the contract. And I'm sorry, but you can't buy my house, right? So what this means is that the seller is never going to be homeless if they have this contingency, because they can void the contract before the end of the deadline. Now, how many days do you put in here? Well, you put the number of days that you think it'll take based on what your client's looking for and what the market's doing. You can couple this with a post-settlement occupancy. This can be extended. You're not going to use this with a buyer's home sale contingency contract because that buyer needs a place to go because they're selling their home. This needs to be a very flexible buyer. But this is something that can help free up inventory if we make sure our buyers know or our sellers know that they won't be homeless. You also would put this information in your listing that seller needs home of choice contingency. Okay. General, please don't use this unless you talk to me because it says the contract is contingent until 9 p.m. blank days after the date of ratification. But unless you have the correct verbiage in here, like somebody can void, deliver notice to void, or you might not actually effectuate what you're trying to do in this general contingency. So just be aware that it's there, and I'll help you if you think you need to use it.
Shannon, quick question. Back up on the contingent on seller purchasing another home. Is there a maximum time that we can do for closing? Like, let's say they know it's going to take a while to find the right home. Maybe can you do a 90-day closing?
Sure. Yeah. What it'll affect is the buyer's ability to lock their interest rate. And that's usually what it comes down to, is that the buyers will agree to something that's a reasonable amount of time for them to lock their interest rate, and then they will do a post-settlement occupancy for the rest of the time. Section 2 here is on backup contract. 2A says the contract is the first backup offer to another contract dated blank between the seller and somebody else. So if you're submitting an offer as a backup, the seller has to tell you what day the contract was dated and who the buyer is. You could have multiple backups. I had a situation one time where I had 3 backup offers. So somebody was a backup to a backup to backup, right? So it wasn't just the first one. And we actually ended up not selling to the first one. We went through the list. There's also a place in here for you to indicate whether the deadlines are measured from date of ratification or the date the contract becomes primary. Date the contract becomes primary is the best practice. The settlement date will be blank number of days after the contract becomes primary. Fill something in here. So you're going to put a settlement date in your offer, right? But this supersedes the date that you put in your offer. The buyer may void this backup offer at any time by delivering notice to the seller prior to being told you're in first position. The EMD does not get delivered until after you're in first position if you have checked the box that says date this contract becomes primary. Okay, very important. As is.
Actually, I have a question about the backup contract.
Okay.
It never happened to me. When it says here, seller and buyer, let me see, just to be sure that I understand correct. So the listing agent, he must disclose the name of the buyer that he was under the contract. Understand correct?
Yes, that's right.
Okay, and so this one I sent. So this it means that if I call and my client is interested for a listing that is already under the contract, so that I'm going to submit after, right?
Mm-hmm. Okay, that's right. In the as is section, there are clauses that are in the main contract that can be deleted essentially by using this paragraph. So the clause stating that the property is going to be delivered free and clear of trash and debris, the compliance with the regulations about smoke detectors or termites, local ordinances about the violations with local authorities, and the seller's requirements to comply with property owners association violations related to the physical condition of the property. So you can check those boxes. A lot of times short sales will require that all of those boxes be checked. Unrepresented seller or builder and buyer's broker. This is the paragraph you use when you have a FSBO and you've already had the one-time showing agreement filled out saying they're going to pay a certain amount of money. This paragraph is where you fill it out so that the title company knows to pay us directly from the proceeds. Okay? And how much. The next two paragraphs are related to 1031 exchanges. So this is saying which party is doing the 1031 exchange, and if it's the buyer who the settlement is being coordinated with as far as the intermediary. And if it's a co-op, there are a couple of different rules for co-ops. And so this, very rarely will you deal with a co-op. I think there's one building in Arlington that's a co-op. And this says that the seller has or will deliver the public offering statement on the co-op. And if it was delivered prior to ratification, the buyer has 3 days from ratification to void. Okay, if it was delivered after ratification, then they have 5 days from receipt of the statement. Okay, awesome. So let me go back. Let me just make sure. Shannon, are you still here? Yes, okay, awesome. All right, so I'm going to talk for a second about the title paragraph. So those of you that have been through class with me before, any class, or have had any issues, and even earlier in this class, you remember me when we were going through the title paragraph, we talked about HOA violations, right? And we talked about how sellers have to fix those, that it's different from home inspections, etc. So in the title paragraph, one of the benefits to our buyers in previous iterations of the contract was that there was a sentence that said that if clear title couldn't be delivered, that the buyer at the buyer's option could void the contract. Okay, so if the seller couldn't deliver clear title, and for our practices, we used this when the seller was not delivering the HOA cure letters and the condo violation cure letters to us. And the buyers knew that they could walk away. Now they could still close with the violations, but the sellers needed to understand that the buyers could walk away. So there are other things that happen, right? With clouds on title and judgments and other things that cannot always be cleared before settlement. And the buyers then could have the unilateral ability to void the contract. And that sentence was taken out. And when we were going through the title paragraph, now David Robertson had reached out to Matt Triani, who's the chief counsel at NVAR, and I sit with him regularly on the forms committee. And I had been talking to David and talking to Shannon, and we were going back, about why this sentence was taken out, giving the buyer that unilateral right to void. So as we're going through the paragraph, right, I had an aha moment because even though we were all talking about it, where am I going to point you guys to now so that you know that the violations still have to be taken care of and the buyer still doesn't have to close, right? It's still okay. So that was why I took the call from him, because I wanted him to clarify, because if you guys call the hotline at NVAR, you're going to get him or you're going to get Maria Flax, who's the new staff attorney. So I want to make sure everybody's getting the same message. So basically what it comes down to is that that sentence was redundant, which is why they removed it. In the default section, we talked about how the buyer is not at fault for not closing if there's a breach, right, or default by the seller, right? If the buyer can't close because of default of the seller, the buyer can pursue remedies, right? We had just talked about that. So the seller has a material breach in the contract where they cannot close with clear title, therefore they have not performed. So if the buyer chooses not to close, if they have performed in all other manners up until that settlement date, then it is the seller who is at fault. All right, does that make sense to everybody? So even though the buyer is not going to deliver notice to void like we would have before, where they would have delivered the notice to void and cited the HOA violations or whatever they would have done and said, I'm not closing because you didn't give me the cure letter, or I'm voiding because you can't cure the title issue, or whatever they would have delivered before. What's happening is it's just taking us through midnight on closing date, and then the seller has defaulted. The buyer is still doing everything that they have the power to do to perform, even though the seller has stopped them at a certain point, right? And certain title issues might prevent them from performing, like having the loan docs even, right? Because they can't get title insurance, because they can't get clear and marketable title, or they can't get the title insurance issued without that additional risk premium. So they might not even get to the closing table because they can't, because the seller has the inability to perform, okay? But that piece is a little hairier and happens much less frequently than a seller who says, whatever, I'm not taking care of the HOA violation, sue me, right? So that's how we can explain, even though that sentence that explicitly gives them the right to void is taken out, they're still not at fault. The buyer's still not at fault because they can't be forced to close when the seller hasn't performed, okay?
Shannon, if that's the case, what is the consequence for the seller? Because the buyer performed. If it was the other way, it was the earnest money at stake.
Right. So the seller, in the default paragraph, it says that they can come after them for financial damages, or they can sue them for specific performance. Okay. So at that point, depending on which side we're on, right, we may have to refer to an attorney. And in some cases, they just want to cut their losses. And if we're on the buyer side, we get the seller to sign the release to get them their money back and take them to find a new home, right? And then the seller licks their wounds, fixes what they need to fix, and everybody moves on. And in most cases, that's what happens. The release is signed, everybody goes their separate ways and does what they need to do. There's usually not any sort of litigation or attorneys, fighting each other that happen at that point. Okay. And when you get an inkling that your clients are not going to be able to close, or there's an issue or something, my magic wand works a lot better when I know before closing instead of after closing was supposed to happen. So bring me into it to help, at least with the conversation. If we can't get it to close, we can't get it to close, right? But we might be able to sign a mutual release early and get everybody on their way, or explain the scenario, or find some sort of solution so that people understand what's happening. Okay, Shannon, did that help at all? I wanted from you what you guys were looking at.
Yeah, when Dave was talking about it last week. Is that what you're asking me?
Yes.
Yes, yes. Yeah, I think that answers would answer his question.
Okay, perfect. And so and one of the reasons why I wanted to make sure I explained it to the entire group was because agents on the other side might hear that sentence was removed. And then they're going to say, well, guess what? The buyer's right to void is not there anymore. So tough luck, go to closing, right? So now you know what to say when somebody on the other side was smart enough to know that it was removed, but not smart enough to know what the implication was that it was removed. Okay, so it still doesn't affect the practice really, except that it can't, nothing's going to happen on the date of settlement. It's going to be the date after when the default happened. Okay. Awesome. That is not the document that I was trying to share. Nobody needs to go into referral. You guys are all selling, because in referral, you can't sell. Okay. Escalation addendum. This is a confusing document. And I don't know why it's so confusing, but it is confusing to a lot of agents. So I'm going to try to make it not confusing. This first paragraph says that the buyer is offering to pay the seller a certain amount of money above another offer's net price to the seller, not to exceed a maximum sale price. That's what that paragraph says. So this first line is the escalator, right? So this could be 500, 1,000, 1,500. I like to use random numbers. So a lot of people use 500 or 1,000 or 1,500. You can use a really high number like 9,000. John Walker likes 9,000 or some high number. You could use something unique like 3,579. And then a maximum sale price, which is the maximum that your client is willing to pay. Think about the number that you fill in here and how it relates to your escalator. Okay? Because most people use round numbers. If you're not using a round number, then don't use a round number in your sale price that they're going up to. Okay? Now, down here, it says, are they going to waive their appraisal contingency or are they retaining their appraisal contingency? You cannot waive the appraisal contingency with VA or FHA financing or USDA. So you can't check this box if they're doing VA, FHA, or USDA financing. Now this box, this is where it gets really tricky for a lot of people. In this section here is where the second highest offer information gets filled in. So the offer, if you're the winner, the offer that you beat goes here. The sale price minus any concessions that were asked for and the net price here. The net price plus your escalator from the top goes here as long as that number does not exceed your maximum offer price from that top paragraph. Okay. If it's in between, like the net, let's say we'll use round numbers. Okay, your offer price was 500,000. You're willing to escalate by $1,000 increments up to 525. This offer right here was a net price of 520. Your offer would be 521. If this net offer for some reason was 524, 500, your price would not be 525, 500 because that exceeds your escalation. It would still be 525, okay? Now, what I want to say is that this escalation addendum is used only when the offer that's winning is the highest price. There are many times that a seller decides to take an offer that's not the highest price. And that's okay. You just do a counter offer. This escalation does not apply, this addendum, if you are not filling in information here that makes the escalated price higher than offer number 2. If you're in a situation where you're a listing agent and you have a bunch of offers and you want to accept an offer that's not the highest price, but you want to escalate their price, okay? So they had an escalation addendum that took them to 525, but somebody else offered 550. So you want to escalate them to 525, but you can't use this escalation addendum because they're not the highest offer because somebody else offered 550, but it's a much worse offer in the other terms. It is a good practice to still show them the other offer so that you're justifying why you raised their price to the 525, but you don't use this addendum. You simply counter on page 1. In addition to filling out this information here, the full offer from offer number 2, second place offer, has to be included. So many times I see an escalation addendum when I'm reviewing contracts and compliance, and I have to return it and say, I need the escalating offer. So everything has to be included. The full escalating offer has to be included, or it might not be considered ratified. Okay, Anna.
Included for the other agent or for you for compliance?
Both. It's not a ratified contract unless you have sent back that document.
Okay, thank you.
Okay, Anna.
So, and I know I'm beating a dead horse right here, but so if, for instance, you were to feel, you thought you had ratified offer number 1, you never sent over offer number 2, it gets to a week before closing, does the buyer still have a right to walk away because technically it's not a ratified deal?
Yeah, because they don't have proof. Yeah, we actually had that happen.
Okay.
You have to let them out.
Second question is, with the escalation, and you might have covered this and I just missed because I was multitasking. Once you've got the escalated amount and you fill out that page, do you need to update the price on page 1 of the contract? Or is that just a nice thing, an easy thing to do?
Yeah, you don't have to. It is enforceable when it's filled in right here. And if either party requests it, then the other party has to comply and initial, but it is not necessary.
Thank you.
Question, Shannon?
Mhm.
On when you said the complete offer, so I had seen in the past someone would just send over like the first page of the contract. You mean the whole contract, contingencies, everything, right? They need to send the whole offer package.
Yeah, complete means complete, not page 1. Because it says right here, seller shall provide to the purchaser a complete copy of the other offer used to justify the escalated sale price with this addendum. So complete is complete. All right. Another very confusing document for many agents. Seller's post-settlement occupancy agreement. Seller's post-settlement occupancy agreement is for holdover occupants. This does not make a landlord-tenant relationship between the buyer and the seller. Speaking of which, if there is a tenant in the property whose lease does not expire until after closing, this document does not apply. You do not use a post-settlement occupancy agreement to extend the tenant occupying the property into the buyer's time that the buyer has owned the property, okay? If a tenant occupies the property and the seller sells, buyer buys, tenant still living there, crosses over closing, right? Seller is no longer the landlord, buyer is the landlord. Seller needs to give buyer the lease. Seller needs to give buyer the security deposit. Buyer needs to honor the terms of the lease because buyer is the landlord. Post-settlement occupancy agreement does not apply to tenants living in a property, nor does it create a landlord-tenant relationship between the seller and the buyer. Okay. Now, when a buyer is offering a post-settlement occupancy to a seller, they can charge a daily rate, they can charge a flat fee, or they can have the title company calculate a per diem to cover the buyer's actual carrying costs for the days the seller will be occupying the property. If the buyer is offering the seller a free post-settlement occupancy, you would check the box that says a flat fee in the amount of, and you would put 0. Okay? Excuse me. In the second section, you fill in the occupancy deadline. So this means that the seller has to vacate on or before 9 p.m. on whatever the date is that you put in. If the seller vacates before, then there's a provision for the buyer to refund any unused portion of the occupancy charge if they're being charged, or they won't refund. So what this means is if they are being charged like the per diem carrying costs, and it's a full 60 days, the buyer is collecting the full 60 days from the seller at settlement. And if they want to allow the seller to leave early, the buyer can say, okay, if you leave early, I'll give you back the money. If you leave after 30 days, I'll give you back 30 days worth of your money. But they can also say, look, Mr. Seller, I didn't have a way to get my money back for where I had to stay. So I had to pay them because you said you needed 60 days. So I can't refund you any of your money. I'm sorry. It says here that if the seller is vacating before the deadline, they have to give at least 3 days written notice. If the seller fails to vacate before the deadline, the seller has to pay double the daily occupancy charge or a flat rate per day. Well, if you're giving them a free post-settlement occupancy, then you need to put in a flat fee per day. My suggestion is to put in a flat fee per day that discourages sellers from overstaying their welcome. So calculate what your client's daily expenses would be and double it and put it here, or double it and plus something, right? Like $200 a day, something, so that it discourages the sellers from squatting. The seller is also responsible for any reasonable expenses incurred by the buyer should they fail to vacate. Now, property maintenance and condition. This is something that we as agents need to make sure we talk to our sellers about very clearly when they need a post-settlement occupancy. This is not a landlord-tenant relationship. I know I've said this multiple times, and there's a reason I say that, because at some point, somebody is not going to remember or not repeat it enough to their client, and their client's not going to remember. The seller has to deliver the property to the buyer at the deadline in substantially the same condition as it was the date of settlement. So that means if the HVAC system was working on the date of settlement and it breaks a week later, the seller has to fix it. If there is a roof leak a week after settlement and there was not a roof leak at the date of settlement, the seller has to fix it. The seller is essentially still the homeowner for maintenance and condition purposes, okay? If the HVAC goes and there's a tenant, they call the landlord and say, my heat doesn't work, my air conditioner doesn't work. Send somebody to fix it. That's not what this is, okay? Security deposit. The security deposit is held by the escrow agent, generally the title company, and the buyer gets to use any or all of the security deposit to defray costs incurred by the seller's non-compliance. So if the buyer chooses not to do a walkthrough prior to settlement, they don't get to keep any of that money for damages when they go to do the walkthrough when the seller moves out, because they don't know what the condition was. Now, if the seller moves out a couple days later, then they can apply the per diem towards that security deposit. They don't get to go and do a walkthrough and find all of these extra things that they didn't check early on. They don't get to use it as a home inspection. They don't get to say, oh, well, the hot water heater is old and now I want to go and replace it, so I'm going to use their security deposit. That's not what it's for. Security deposit in a post-settlement occupancy should be commensurate with the size of the property and the purchase price. Okay, this should not be tens of thousands of dollars. This should be generally in the $2,000 to $3,000 range. This should not be earth-shattering amounts of money to either party. Okay. Within 3 days of the occupancy deadline, the agent has to send a list of deficiencies to the other party. I'm sorry, the parties have to send a list of deficiencies or they waive any claim. Okay, so if the buyer doesn't go and do their walkthrough until a week after the occupancy deadline, the escrow agent can actually release the security deposit back to the seller. So they are allowed to do that, even if the buyer goes in a week later and it's like, oh my gosh, there's $20,000 worth of damage. Well, they didn't do their walkthrough in time. The seller has to keep utilities registered in their name and pay the costs until the deadline. So my suggestion is if the buyer is going to take possession of the home prior to the occupancy deadline because they've agreed to let the seller out, they need to put something in writing, okay, so that the seller doesn't have to pay the buyer's utilities while they're living there. Risk of loss, the seller is going to have their homeowner's insurance on the property when they go to closing, because that's a requirement of the lender, but they are only responsible to cover their personal property. The buyer has to cover, the buyer has to cover their property. If they have any personal property in there, they cover the house, the lender requires it. The seller has to cover their own personal property. The buyer is not responsible for any of their own personal property in the house, okay? Access. Seller will permit the buyer reasonable access to the property and deliver one set of keys at settlement. So the buyer doesn't get to come in and out as they please. The seller gets bite enjoyment, right? They get to stay and live in the property. but the buyer does have a key. If it's being purchased as an investment property and is going to be offered for rent, the buyer will be able to put up a for rent sign, and the buyer and buyer's agent shall have access to show the property within 30 days of termination of the agreement. So if it's a 60-day agreement, the last 30 days, they can actually show the property. Okay, and the last document in the offer documents is the FERPTA addendum. And so this is just what you would have included with the addendum for someone who is a foreign person. Okay. All right, questions on the offer documents before we go through the much easier post-ratification documents? Nothing? You guys have it all under control. I love it. All right. I'll give you a minute.
Shannon,
Yes.
I'll give you one question. So on the escalation, since we're using so many of the escalations, I remember doing one sale and you had me, after the escalation was reviewed and accepted, that the buyer went back and actually then changed the price to what the escalation was, so we wouldn't have to deal with the escalation amendment. Is that still the best course of action?
It's just preference on the parties. It says on the escalation addendum that if either party requests that page 1 is changed, then the other party must comply.
Okay, but then you don't need to have all the rigmarole and
Correct.
the other. Okay, good.
Correct. Yep. All right. Does everybody have their post-ratification documents ready to review? All right. This should not give you as much of a headache as earlier. All right. Post-ratification. So we have the first document in our packet is the addendum. Now, this document can be used with an offer or post-ratification. Anytime you have a change to the terms in the contract, it has to be done on an addendum. It does not get done back on the contract. So many times I'll review a contract and I'll send it back and I'll say, hey, such and such was missing, or such and such needs to be corrected. And I'll see agents go back and take the ratified contract and make the change and then resubmit it. And that's wrong. We have to do all those changes on an addendum. And sometimes I'll actually say, because of the type of correction, I'll actually say, please make whatever correction on an addendum and confirm the ratification date, because I might think that whatever the item is that's missing could put the ratification in jeopardy. Okay, so everything goes on an addendum that's a change after ratification. The appraisal gap guarantee that we talk about is something that goes on an addendum. We removed, I don't know if you guys noticed, but we removed the other terms section from the contract. And we don't want other terms in the contract. So anything that you guys would have put in the other terms goes on an addendum. So that appraisal gap guarantee goes on an addendum with your offer. Okay, so that would be an example of how an addendum would go with the offer. Be very, very clear on what you're writing. Okay, I've given you guys the language for the appraisal gap guarantee. If there's something else that you're trying to write and you're unsure, write it, send it to me to look at. Okay, I always want you to give it the first shot and then send it to me. And that way we can see if I can tell what it is that's trying to be effective. Okay. The notice, remember
Can
the
you give us the language for the appraisal gap again? I'm sorry.
I'll send it out to you guys later. Okay?
Thank you.
Okay. Notice. The notice is a unilateral communication from one party to another. Now, this notice is not what you use for like voiding a contract or anything like this. This is because there's a document for that. This is not for the appraisal notice. There's a document for that. This is for something else. So this is like if the buyer is changing title companies, this is what you would use because that's not a negotiable term in the contract. You would use this. So if there's anything that the buyer is just telling the other side, you would use this document if the buyer is removing their home sale contingency or home of choice contingency because there's no other separate document for that. You would use this. It's one party telling something formally to another, but there doesn't have to be an agreement. This is the appraisal contingency notice. It probably looks familiar because it's exactly like what we had on the contingencies. And what this is a copy from the contingencies, and your client gets to choose what applies. So the buyer's telling the seller something. They're telling the seller that the appraisal is equal to or greater than the sales price. We're moving forward. They're telling the seller that they're moving forward and it doesn't matter what the sale price is, right? Or the appraised value. It could be lower, it could be higher. They could have not even gotten to the appraisal yet. It doesn't matter, right? They're just moving forward. It doesn't matter. The third choice was the appraisal is equal to or greater than the sale price. However, there's something wrong with the property. It's usually that it doesn't satisfy the lender requirements because of a condition issue. The next choice is the appraisal is less than the sale price and the buyer wants to negotiate a new price, and they'll move forward if the seller agrees to this new price. Or the appraisal is less than the sale price and the buyer declares the contract void, okay? And you use this. So, a couple of things. If the contract is being declared void by way of choice 3 or choice 5, in addition to this document, you would send the release, which I will show you in a moment. You would also send proof of whatever it is that's giving you the right to void the contract. So the appraisal document is generally what you would send because it's showing the value or showing the inadequate collateral, okay? In number 4, right here, this document does not change the sale price. The buyer is saying, hey, Mr. and Mrs. Seller, if you reduce your sale price to this number right here, we'll move forward. Buyer signs this. In addition to this document, you would send a sales contract addendum that says, buyer and seller agree. Sale price is changed to X, whatever, okay? All other terms remain the same. You would also send a copy of the appraisal. The sales contract addendum is what is binding. A seller signing this document is not binding. You need a sales contract addendum. Okay, so if your buyer wants the sale price changed, there are 3 documents: this document, the appraisal document, and a sales contract addendum that changes the price. Okay, next is our inspection contingency removal addendum. This document is what is used to submit a wish list for inspections. Okay, you might do your home inspection separate from your radon inspection, in which case you would send multiple versions of this document. Okay, this document very specifically and purposefully has a small section for your wish list. Okay, the small section for your wish list is because the home inspection contingency is not meant for a wish list to be sent to change the condition of the home from what the home was on the date of the home inspection, the date of the offer. What it is meant to do is to allow repairs to be asked for things that the buyer could not have been aware of when they made the offer. For example, the buyer didn't know that the roof was leaking and had all of these issues. That could be negotiated. But if the buyer is walking up the driveway and sees all of these cracks and all of these issues with the driveway as they've walked up and down the driveway multiple times to get to the home, then they are not contractually allowed to ask for that, right? Based on what our contract says. Now, they could write that they want a Mickey Mouse mural painted on the wall, and the seller says no, and the buyer can void, right? That's a function of the contract. But based on what is set forth to be allowable for the home inspection, it's items that the buyer didn't know about, right? Items that could cause damage to the home while the homeowner still owns it, safety issues that no one was aware of, like an electrical issue, or a system that's not functioning that was advertised to be functioning, okay? Those are the items that are supposed to be asked for on the home inspection. So there really shouldn't be many things that get asked for on here. A complete copy of the report is what has to accompany this wish list. So if your client wants to ask for money instead of a list of items to be repaired, you can put that on here with the copy of the report. The seller agrees to it, and then you would put on a sales contract addendum that there is now a new seller subsidy. And that's what would go to the lender, because you're clarifying what the new seller subsidy is. This is simply a function of removing the contingency, okay? Something new on this that is important, and I kind of touched on it earlier, is related to the repairs. So what this says is that unless otherwise specified, all repairs are to be performed by a contractor licensed to do the work, and receipts are provided, okay? Unless something was agreed to that they wouldn't be provided. And they have to be provided prior to the buyer's final walkthrough inspection. If the seller agrees to make repairs in this addendum, the seller will provide the broker, buyer, and licensed professional insured inspectors retained by buyer reasonable access to the property to make final walkthrough inspections within 7 days prior to the settlement or occupancy. The addendum will not alter, modify, or change this contract except for what was agreed to. So why is this important? The inspector is allowed to come back to check the things that were listed here on the inspection. That's it. Now, what I will say is it's important to know that it says this addendum will not alter, modify, change in any respect this contract, because in order to comply with the contract, the seller simply has to make sure that the repairs are performed by a contractor licensed to do the work and provide receipts. Just because the buyer might not be satisfied with the quality of work does not mean that the work was not done to satisfy this document. Okay, so we have to be very clear with the expectations with our buyers that if they're asking for the work to be done, then it's done to the letter of the contract and the letter of what's written.
Shannon?
Go ahead, Teo.
For receipts, have you seen like a variety of method for that being delivered, or what's traditional to expect the seller to provide for the quote unquote receipt?
I'm not sure I understand the question. If it's a licensed contractor, they're going to have some form of a receipt to provide, whether it's, you know, a handwritten something on triplicate, you know, that has their letterhead, logo, license number, et cetera, on it. They might have a QuickBooks invoice that comes through to them. There's going to be something from the vendor that's provided.
So,
Is
so
there
long
a
as it's
certain,
something from a licensed contractor that is associated with work in the same timeline, that suffices.
is there an example you're thinking of?
Well, I'm just thinking like, you know, if you had 3 or 4 items, like would a quote work that, you know, is signed by both parties? Because I've seen that with people where they'll get like a quote from their contractor and then the work's obviously done. So is that something that would work, or the QuickBooks thing I've never seen, but I guess that makes sense.
Yeah, a quote is not a receipt. A quote is saying, if you hire me, this is how much it will cost. But a receipt doesn't show that it's been completed and paid for.
Okay, so it
So
does have to have the payment associated.
It does have to show that it's been paid for, yes.
Okay, that's helpful. Thank you.
Yeah, absolutely. One thing that I would like to clarify on this inspection contingency addendum is that this addendum is what is binding, not reference to another document. So I have seen several of these that say, you know, fix or repair deck, see page 14 home inspection report. Okay, well, what exactly does the buyer expect, right? So it has to actually say on the document what needs to be fixed or repaired, right? And what the expectation is. And do they want it replaced if it can't be fixed? And the buyer has to make sure that what they're asking for is something that can be done. Because if they say fix such and such, but it can't physically be done, and they didn't say or replace, then how can the seller comply, right? So just be very careful with the verbiage that goes on these. And if you have a buyer who's picky, ask for money, okay? Notice voiding contract. This is important if your buyer is looking to get out of the contract. So the buyer would deliver notice to void, which is this document, a copy of whatever backup documentation might be required per the paragraph or contingency that allows them the right to void, and a copy of the release. So you're going to have 2 things always, and maybe a third, okay? In the case that they are voiding based on HOA or condo docs, there's not going to be any additional documentation. It's going to be this document and the release. If they're voiding based on financing, it will be this document, the release, and the decline letter from the lender. And what you do is you check who's delivering the notice, who it's going to, what paragraphs you're citing. So the undersigned party gives notice to. So if the purchaser is voiding, you're giving notice to the seller, and the notifying party declares the contract void as permitted pursuant to blank paragraph of the contract. So I think it's paragraphs 8 and 9 now that are HOA paragraphs. So if you're voiding on HOA docs, you're going to say pursuant to paragraph 8 of the contract. Or it could be paragraph 3 of the conventional financing addendum, right? So whatever it is that you're voiding on, this is what you put here. And then make sure all the documents that need to be attached are attached. And then the notice is given by the purchaser. Okay. And then this is your release that gets the money back to the purchaser or gives the money to the seller and relieves all liability from the buyer to be pursued for damages if in the event of a default. Okay, so I would like you guys to read through this so that you understand, but basically it says that once it's signed, nothing further can happen between the buyer and the seller. This does not mean that the brokerage may not be able to collect some funds. We might need to get some funds from them. It doesn't mean that you know, they don't still owe money to the title company for a title search or to the lender for the appraisal or, you know, something like that. This is simply between the buyer and the seller. Okay, and it has to be signed by all parties before any money can be released. The money can be split. Some money can go to the purchaser, some money can go to the seller. It's just what's agreed to in the discussions. Now, the next document is buyer's limited access to premises. So I wanted to show you this because in the event of lender required repairs and the seller doesn't want to do the repairs, but the buyer does, you would want to use this document to have clear expectations of what's going to happen. Okay, this is also when you have a buyer who might need to deliver some things to the property ahead of time. I don't like it, but sometimes it happens, and you can have where the buyer can store some personal property beforehand. Maybe they have a pod that's coming from out of state and it's being delivered early before settlement. You know, that would be something that you would use this for, saying that the pod can be delivered ahead of time. Okay. All right, walkthrough inspection. All right, walkthrough inspection. You're going to check yes or no on the things that are checked, right? When you do a walkthrough inspection with your buyers, you're walking through, you're turning lights on and off, you're flushing toilets, you're turning water on in the sinks, you're turning the shower on. You are turning the microwave on, the stove. You're checking to make sure that everything is essentially working the way it was for whatever was stated in the property maintenance and condition paragraph, right? Or paragraph 10. When there's an issue, there are three choices. Seller will correct the discrepancies without an escrow. The seller will credit the buyer, or the repairs will be made and paid from the funds held in an escrow by the settlement agent. And the escrow funds are or are not the limit of the seller's liability. Okay, so depending on what it is, the seller can correct the discrepancies without an escrow. Maybe there were bags of trash that were left that hadn't been taken out to the garbage, right? That's easy. Seller can come get them, pull them down to the trash, whatever, right? Or something minor like the garage door opener. The openers weren't there. So you trust that they're going to deliver the garage door openers to you later. Okay, easy. There's something a little more. You can contact the lender, see if the lender will allow a last minute credit, seller to credit the buyer, whatever. Okay, if the lender will allow the credit, that's the easiest thing. Most of the time it's hard if you're doing the walkthrough right before closing. If there are inspection items, do a first walkthrough a couple of days before closing, so you know ahead of time if you're going to need that credit, right? You can do multiple walkthroughs in that 7 days. So if there's inspection items to check, go a couple days before. And then repairs to be made from the escrow. So escrow also is a little tricky when it comes to lenders. The funds can be paid directly from the escrow, from the settlement agent, or reimbursed to one of the parties. If they're being reimbursed, everybody has to agree who they're being reimbursed to. And sometimes it's not the limit of the seller's liability. So maybe they don't put enough money in to the escrow account, and they might have to actually pay a little bit more to whoever the contractor is. Okay, if everything's fine, only the buyer signs this walkthrough form. If it's not fine, then buyer and seller have to sign. In compliance, I ask for a copy of this walkthrough from everybody. Okay, it's to protect all parties so that a week later, when something breaks, you have record that everything was fine on the date of closing. Broker credit letter. So many of you missed Ask the Broker last Friday, where I talked about the broker credit templates being in DocuSign. So I just wanted to show you the broker credit template that's in DocuSign. So what you guys can do is fill this out and send it to me. And once everything is approved in Command, I will sign it. Okay, so I just wanted to include it in our class so that I could show it to you. It is in the Office Documents folder in Command. Extension of review period for HOA or condo doc. So this is the document where you would be agreeing with the buyer and seller to extend however many number of days. So you have to fill in the blank on how many days right here. If it's 1, 2, 3, or 4, it cannot exceed 4 additional days. And this can be done with your offer or after ratification. Okay, that's the last document and it's 4:30. Woohoo! All right, so questions? Did I go through that all way too fast?
I have a question.
Hi, Young, ask your question.
Well, it's a statement. Earlier you said, oh, we all got it. It happens when we're in the middle of it. Then even if there's no way you can compute everything and it's like you'd be a robot. So we love this. I love this, but I'm going to need you. I don't remember all of that.
Okay, well, I hope you need me because I like my job. And if you don't need me, then I don't get to keep my job.
Okay, bye.
All right. I want questions and ahas. You don't get to log off yet. So, all right, Emma, you have your hand up.
Yeah, I have a question. So this is kind of a specific question to a rental contract, which I've been working on with Christina. So I don't know if this is appropriate for everybody or I should talk to you separately, but basically we have these people, they're not our clients yet. We're in the process of talking to them about being our clients and they're the landlord trying to find a tenant and they have concerns about the contract. So we just had questions about that.
Okay, so we're going to do a separate class on rentals that is not yet on the calendar. So I have to find the date for that and I will put it out there for you. So Emma, we can talk specifics when we finish class today. You can stay on with me and we can figure out what their heartburn is over it.
Perfect, thank you.
Okay, absolutely. All right, I need questions and I'm gonna need at least 3 ahas, something that you learned that you didn't know before.
Does it count if I said I didn't know any of it?
Well, it kind of counts, but or something that surprised you since you didn't know any of it. If there was something that was surprising to you that you learned that you thought should have gone a different way. Because there are many of you on here that are experienced. So
For me, the escalation clause that we only send, I thought we were obligated to send only the front page, not the complete contract. So if
Okay.
that's not happening, it was not ratified. So it's like, that's crazy.
Yep. All right, good. Allie, you got any ahas in your room or from you?
I have a question.
Okay.
So it pertains to defaulting and I saw in there, I've never had this happen to me, but I saw in there that, whoever's the defaulting party could be responsible for broker fees. So if you represent the seller and the buyer defaults, does that mean that the buyer is going to pay your commission?
Okay, so maybe there can be a situation where all right, so let me see if I can explain this outside of my head in a way that makes sense. When you have a listing, you are saying that there's a total commission coming in, right? And that your job is to find a ready, willing, and able buyer, right? If you find that ready, willing, and able buyer and the buyer defaults, then you've still done your job, right?
Right.
And so the seller still could be obligated to us for that commission because we did our job. Settlement is not actually what has to happen for us to earn our commission, right? The activity of going to settlement is how we collect the funds, but when we earn the money is not at settlement. We've earned the money prior to settlement. So if a buyer defaults, then the seller owing us the money, this really means the seller could go after the buyer in that default situation in their damages, right? So that's why there's some language around that the other party could actually owe those broker fees because it could be included in the damages. Does that make a little more sense?
Yeah. Thank you.
You're welcome. Great question. I love that you read that. Leah, you have a hand.
Hi, Shannon. I have an aha and a question.
Okay.
So aha is that I always thought that the seller was required to do the lender repairs. You know, if they require it, especially if the appraiser requires that.
Yeah.
So it's good to know that they don't necessarily have to do, but they could provide access. So
Yeah.
For me.
Awesome.
Yeah. The question has to do with the HICRA. And I had a situation where the buyer asked for a certain amount of money and the seller refused because the seller thought that the amount that she was asking for was in excess.
Okay.
And in order to not void the contract and let the sale go through, well, the listing agent decided to contribute some money towards the repairs. But what should have happened in that situation? Basically, if they could not come to an agreement on the repair, the amount that was required for repair.
So everything would have needed to be addressed in that negotiation period. There's a couple of things that can happen. And I will tell you that I don't mind broker credits for situations like that where the clients can't get out of their own way and you're trying to save the deal. Like that's something that is, in my opinion, an okay reason for a broker credit. So what I would suggest in that situation is that during the negotiation period, the seller agrees to the total credit to the buyer, and then the agent gets a broker credit letter to their client to offset whatever amount they want to offset. Okay. The other option there is that they reduce the credit from the seller and that other agent can give a broker credit to your client.
Okay.
Okay. So you can give a broker credit to either party, right? An agent can give a broker credit to either party in the transaction as long as it's signed, right? So like if you want to give a broker credit to the other side for whatever reason, we can do that. You just have to tell me. That's why our template says buyer or seller. It doesn't say our client. It says buyer or seller. I want to know which party we're giving the credit to. So those are the two options, right? The seller says, okay, fine, I'll sign off on the whole thing. And then they work it out with their agent. Or you get a credit letter from that other agent for your client for the difference that the seller wouldn't pay.
Thank you.
You're welcome. All right. I need one more aha or whatever questions are still remaining.
I'll give you an aha. I think the, it was interesting on what's actually ratified. And kind of just assuming like I'm initialing, I put the ratification date. I've emailed it over to you, so it's fully ratified, but the other party never received it yet. So that's kind of interesting.
Yeah. Yeah. And that's very common, right? Because just in practice, we think that, oh, we should just put the date on, right? And it's easy. And I think that it's still okay to put the date on as long as you're communicating, right? It's communication causes all problems and solves all problems, right? All right.
Shannon, real quick.
Yeah, Michelle.
Any chance you can do this class for GCAR and MAR forms?
Yes, please.
Did you guys know I hate DC and Maryland? Yes, I will. I did. What did I do in October? Did I do DC? Is that when DC? Yeah, I did GCAR because DC changes in October every year. So I did GCAR in October. Yeah.
We have a recording video for it.
You know, I forgot to record it. And so we'll do it again.
Thank you.
I will get them on the calendar. I will be honest, I'm not as good with those as I am with Virginia. I don't need to look at the contracts in Virginia. So I think that's why I'm hesitant to teach those.
I have an aha moment, Shannon.
Okay. All right, see, go for it.
So besides the ones that Musina and Jeff talked about, for me, it was the property maintenance and condition inspections to do the date for the reasons that you expressed on date of offer. That makes a lot of sense. And I wanted to say thank you because your classes are extremely helpful, especially for, for new agents. And every single class that I've taken with you, I've learned plenty of things. So I'm on your classes every single time. So thank you.
I appreciate that you come. And I know that we say that these are required, and I know that it still would be easy to not show up because what am I going to do, right? So I do appreciate all of you taking the time, and especially sitting on Zoom all day. It's hard. It's really hard to sit on Zoom all day and listen to contracts. So I really applaud all of you for spending the time with me.
Well, we applaud you because as hard as it is to sit here and listen, I can't imagine sitting there talking for 6 or 7 hours like you do. So thank you.
All right, I will open it for one more opportunity for questions, and then I'm going to let you guys go. All right, I will let you guys go. We will get this recording up, and I'm going to tell you guys now, I am not going to do Ask the Broker tomorrow. I yapped at you enough. I will not going to do Ask the Broker tomorrow, but you know how to ask the broker, right? So you can still get to me, but we will resume Ask the Broker next week. But I'll give you guys a break from feeling obligated to hop on a Zoom with me. Okay. Thank you guys. Have a wonderful rest of the night.
Thank you. Have a blessed night.
Thank you.
Thank you, Shannon. Really quick.
Thank you, Shannon.
Where would this be recorded at? I mean, where would we be able to see the recording?